There's been some talk about the Adkins woman having said something to a cellmate which gave you a lead, but it's my understanding, correct me if I'm wrong, that she simply confirmed some of the things you already knew.
She confirmed some of the things we already knew, and she did tell us some new things which we hadn't heard before.
Mm-hmm. Now, how about a man I've heard of, a burglary suspect in your Venice division, who also supplied some information?
Yes, he supplied the information a few days after we had originally started our investigation and had talked with the sheriff's investigators on the Hindman case. This man who was in jail in the Venice division did supply some information and names of additional people who might help us and supply additional information.
Aside from the people we've just mentioned, are there any other persons, men or women, who have supplied additional information for you? Perhaps you can't give us their names at this time, but...
No, I can't give you their names, but there was another girl who assisted prior to Susan Atkins starting to talk. Her name was given to us by the sheriff's office. She had also assisted in the Hindman.
Turn around once, girls, will you? Turn around here, girls.
First of all, I believe it's very clear that Mr. Manson always has been denied counsel of his choice in this matter. Back in December, he was asking to have Mr. McKissick and Mr. Steinberg as his attorneys of record, and I would hope possibly to try and get them involved in this case, possibly even to substitute out and have them substitute in.
Is this your first case that you'll be trying?
Yeah, this will be the first case that I've ever tried.
How long have you been an attorney?
Just since last June.
And why did you want to get into this one?
Well, I believe that there are a lot of things going down in this case, just as in the Chicago 7 cases, and there's a lot. I think you would have a much better shot if you weren't talking with me, but you were picking up some of the friends of Manson over there who were singing.
Are you going to go ahead with the psychiatric examination?
No, we've withdrawn the psychiatric examination. I've seen Mr. Manson in county jail for probably more than any other attorney, 70, 80 times, and it's certainly my feeling that Mr. Manson is sane. There's no question about his sanity in my mind.
You feel you're capable of defending that?
I believe that probably, as Mr. Manson stated earlier, that no man is capable of representing another, and that I feel that it's unfortunate that the court is screwed around, if you pardon the expression, with Mr. Manson's representation, that it's because of the things that the court has done that Mr. Manson was originally forced to go pro.
Ron Hughes just told me that this will be the very first case he's ever tried of any kind. Do you see him substituting out a little later and Mr. Manson substituting someone else in?
I cannot predict what
Mr.
Manson will do.
Well, how long legally can a defendant keep substituting attorneys?
I think that this will be his last substitution because he has chosen Mr. Hughes. He's consulted with Mr. Hughes on at least a dozen occasions that we know of, and so he knows what he's getting when he asks for Mr. Hughes, and Mr. Hughes can also consult with the other attorneys who have many years of practical experience and trial experience.
What's your answer?
Good morning. Good morning.
Ray?
Yeah. Hey, Rich? Rich? Mr. Hughes, give us your, would Would you give us your comment on the procedure in there today?
Well,
You've been
first-
substituted in as Mr. Manson's attorney. Sure,
Experience at all?
No, I'm not.
you feel you're fully capable of defending a man charged with 3 counts of conspiracy and 4 counts of murder?
Well, he's charged actually with 7 counts of murder and only 1 count of conspiracy. Allow him to have associate counsel, and then from other things that the court has done, this has later forced the court to take that pro per status away. Mr. Manson at points was getting very close to a number of truths, exposing the system of criminal justice that we have in this country, that a man who is allowed to defend himself is, on paper, is allowed to defend himself, but in actuality, he was not allowed to defend himself. As you recall, at one point, Mr. Manson wrote a letter to the district attorney pointing out that the terrible odds that he was at, that the district attorney had these wonderful facilities in which to try and convict him and seek his death, and yet Mr. Manson had to wait for an hour and a half to make a 10-minute phone call.
You said
Seek the pro per status again.
I would hope to get Mr. Manson's pro per status back. I imagine that will be very difficult, and it might very well be impossible.
Tell us something about yourself, Mr. Hughes.
Reiner came into court this morning with a signed motion in his briefcase making him the attorney of record. Yet Manson substituted you in at the last moment. Was this a last-minute decision? Did he have something up with Ira Reiner until he came into court this morning?
I'm really not sure about that.
Mr. Hughes.
Now let's talk to Aaron. Roll on this. Where do we stand in this matter now?
Well, we stand that was set for trial on April the 20th, 1970. The case is presently set in Judge Keene's court. Next week on March 24th, Ms. Krenwinkel makes a motion for a change of venue and for a motion to dismiss. If those motions are denied, then her case too will be set as it is now for April the 20th. We're prepared to go to trial now, and we're prepared to go to trial against this so-called common defense.
Is due to go to trial the 23rd of April in Santa Monica on another matter. She's due to go to trial here on the other matter.
Yes.
Now, how's it going to work out?
Well, she can't be in 2 places at once, so if this trial starts before the other one will have to wait for her to get finished
It'll
here.
have to trail then.
Yes.
Thank you.
Several things happened today, among which is that Mr. Manson's petition for a writ of habeas corpus, the court held that inasmuch as Manson was not pro per at the time he filed that motion, that he did not have standing to file the motion with the court. He had an attorney of record, Ronald Hughes. Hughes should have filed the petition for a writ of habeas corpus. With respect to Susan Atkins' motion to set aside her admissions and confessions at the grand jury, the court held that the motion today was premature, and the trial court would have to hear that motion once the trial commenced.
Mr. Cavallaro and I were subpoenaed as witnesses by Mr. Shin, Miss Atkins' attorney, and on the representation by Mr. Stovitz of the District Attorney's Office that the people would not rely upon her confessions or admissions or statements. The judge ruled the matter was not before the court this morning, and the entire matter went off calendar.
Does this mean that her grand jury testimony will likely not be entered in the Manson trial?
At this moment, that is the indication, yes.
Day, you represent Susan Atkins.
That's correct.
Now, I understand the rumor is, and maybe you can confirm it or deny it, that she is going to deny that everything she said on the witness stand in the grand jury is true.
That's correct. She's going to deny all her statements made at the grand jury.
No song today.
Paul, the judge put off calendar the motion to suppress certain evidence by Susan Atkins.
That's correct, Dick.
Now, maybe you can't comment on it this time. That Susan claims that she was inadequately represented by Mr. Caballero, and that the whole thrust of the defense was to sell a book.
Oh, that is totally untrue. I have personal knowledge that Mr. Caballero was going to save Susan Atkins' life. Now we'll see what happens. I can say that with some authority, that Susan Atkins couldn't have been better represented by any lawyer in this country. And when you consider the scope of the offenses that are charged in the indictment, and you realize that Mr. Caballero, in effect, saved this young lady's life, I think any statement that she was not adequately represented is totally unwarranted.
Without using the grand jury testimony, would you have an estimate, being familiar with the case, about what the state will have to rely upon now?
Well, from independent knowledge not gained from Ms. Atkins, I've learned that there are independent witnesses to whom she's made statements, quite apart from grand jury testimony. And of course, the people have substantial circumstantial evidence upon which they can rely. And I think that will be the main thrust of the prosecution's case.
Thanks, Paul. Craig, are these records subpoenaed in ducis tecum in regard to the removal of Susan Atkins from the facility at any time?
Yes, we received a subpoena ducis tecum for records of removal and visits during the month of December.
But you were not called to testify today, so undoubtedly you can't discuss what's in there.
That's correct, sir.
But they do pertain to Susan Atkins.
Yes, they are records concerning her stay at Civil Brand.
And you're the head ramrod over at the jail.
Jail commander, yes, sir.
Thanks, Craig, very much.
Does this have something to do, Craig, with her activities in the jail?
The subpoena is for removal records, orders to remove her from the jail for various appearances, and for persons who visited her during the month of December.
You would have to explain that to me if you can. Remove her where?
A removal order is when a judge orders that a person is taken to a certain court, like the grand jury or a different court to testify. Any court order is a removal order.
Let me ask you this, Craig, and if you can't comment, just say so. Do these records have anything to do with Susan Atkins being taken from the jail to the attorney's office in Beverly Hills?
I don't think that I can disclose the content of the order, sir.
All right, thanks, Craig.
Thanks, Craig.
Vince, succinctly as you can, what happened in that grand jury is true. Will she be subject to perjury?
She may be. I don't know. She may be.
What will you advise her to do in this instance?
Well, we were trying to have a hearing today to strike a testimony at the grand jury hearing.
Mm-hmm.
And if they do strike that, then they would have to dismiss the indictment. Mm-hmm. Then they may pursue her for maybe perjury.
I see.
But perjury is better than murder.
Thank you, Dave.
Okay.
Paul, you asked for and were granted a discovery motion in the court this morning. What's that for?
Well, we'd previously asked that the prosecution turn over to us statements of people who had confessed to the Tate and the LaBianca homicides. We also asked that the prosecution turn over to us substantial evidence they had in their possession that would indicate that persons other than the now defendants committed the Tate LaBianca killings. We want to examine at length and very carefully the statements of other people, the physical evidence of other people. There are a number of people who are prime suspects in the offenses before the court, and we just don't have that information at this time, and we need it in order to prepare our defense. Our defense may well be that persons other than Charles Manson, Patricia Krenwinkel, Leslie Van Houten et al. Committed this offense. There is substantial evidence in existence that people other than them committed this offense.
Thank you, Paul, very much.
In my opening statement, I said that these murders were perhaps the most bizarre, savage, nightmarish murders in the recorded annals of crime. And I think that Linda Kasabian's testimony on that witness stand today illustrated what I was saying in my opening statement. She was filled with emotion in describing the first night of horror, the first night of terror. there's no words to describe what she was saying, and only she was there that night. She heard the unbelievable screams, the pleading, the begging. How do you describe what happened that night other than in her words?
What was her vantage point?
Her vantage point, she was in the driveway at first, and she heard these horrible, horrendous screams coming from men and women, constant screams, pleading for their lives, coming from inside the residence. At that point, she ran up to the residence. She wanted the carnage to stop. She saw Frykowski coming out the front door. His face was bathed in blood. He fell into a bush. He staggered up. Then he fell into the lawn. She saw Tex get on top of him, stab him repeatedly, club him over the head. Frykowski was struggling, begging, pleading for his life. He was screaming. And contemporaneous with that, she saw a woman in a white gown who has been identified now as Miss Folger running in the back part of the lawn, and Patricia Krenwinkel chasing after her with an upraised knife. That's basically been her testimony with respect to the murders. Now, she did not see the murder of Sharon Tate or Jay Sebring. The testimony will show that that took place, of course, inside the residence. She, of course, also did testify that she saw Tex point the .22 caliber revolver inside the driver's side of the vehicle and shoot Stephen Parent to death by firing the gun 4 times.
Has she always been this emotional in describing these events?
Every time she comes up to this point, she cannot contain herself and she starts to cry. She's a very sensitive, delicate girl, and I think you glean that from her testimony today on that witness.
She was not in on the plot from the beginning, she claims, then. She didn't know what was going on until she got there.
Well, her testimony is she thought they were going out on a creepy crawling mission, which was described by her as a mission wherein the members of the family would dress in black and go into strangers' homes in the middle of the night, creeping and crawling and stealing what belonged to them in the first place. Perhaps the correct word would not be steal in their mind. These sex orgies per se have no independent significance. However, you heard Linda's testimony today. Mm-hmm. She said that he was calling all the shots at that sex orgy. He was the one that was deciding when the orgy would commence, who would touch whom. There was no sexual activity until he gave that instruction. We are offering this as one further indication of Manson's power and control and dominion over that family. We don't intend to tell the jury that out of a clear blue sky, he ordered his co-defendants to commit these murders. And this was the first order he had ever given other members of the family. We are putting on previous contacts with the member of the family, his association with them, his relationship with them, as circumstantial evidence that on the 2 nights in question, it was he who ordered these 7 murders. The sexual conduct per se, as I've indicated, has no significance.
Shouldn't say that she attempted to smuggle a note. She handed a note to Charles Melton, who was with me, and he gave it to Linda. We've never kept anything from Linda that they've sent in. I'm tired of it. I think it's time they let her do as she pleases. They've attempted for months now, even going so far as to sit down in front of my law office to intimidate her and me. I got a phone call a couple of weeks ago from a guy about 8:30. He says, if Linda Kasabian takes the witness stand, neither of you will ever leave the courtroom. And I said, at nighttime, I said, look, do me a favor. If you're going to threaten me, do it during office hours. I'm tired of it at night. This is just another example of this kind of damn foolishness. There's nothing we can do about it. It was upsetting to Linda. It was right before she went on the stand. I was followed all the way upstairs to where she was, and she tried to force her way in and screamed out, in addition to that, something to Linda which was incoherent. And we're just bloody tired of it, period.
Well, is there anything that the district attorney's office or the court should do about this or can do about it?
That's up to the district attorney. It's been many years since I was in that position. All we want to do is have her finish testifying and leave town.
That I might point out that Sandra Good is a friend and acquaintance of Linda Kasabian. I don't see anything improper in attempting to speak with her. I mean, I don't know the circumstances and the rules and regulations regarding the passage and notes in the Hall of Justice, but I on the face of it, I don't see anything improper.
Certain weapons which were taken to the Tate mansion, she testified to certain killings and things she saw. Can you relay to us what she said on the stand?
Well, it's hard to summarize a full day's testimony, Dick.
Anything substantial she said this afternoon that you hadn't heard from her before?
No, the prosecution, in fact, any attorney worth his salt, does not call a stranger to the witness stand. I've talked to Linda for hours, and I'm not going to deny that. And I'm sure that the defense, when they call their witnesses to the stand, they've spoken to them. You don't call someone to the stand and say, where were you on a particular night, and have the person say, I don't know what you're talking about. On this particular night, I was in Beirut, Lebanon. I have no idea why you're calling me to the stand. You talk to them and find out what their testimony is going to be and determine that it's relevant. So her testimony did not surprise me. Night, she had no idea, according to her testimony, that murders were going to be committed.
Do you have some idea how she's going to bear up under cross-examination?
I think she's going to hold up very, very well, Dick. When a person tells the truth, as I believe she is, it's pretty hard to destroy that person's credibility.
Vince, with all the obstruction of tactics, have you been looking at the other defendants? How do you think they're taking it?
I'm so caught up in the questions and answers of our star witness that I'm really not looking to my left.
Paul, I understand that you and perhaps some of the other defense attorneys are a little unhappy about certain Manson family members being excluded from the courtroom by method of subpoena.
That's correct. First, I don't believe there is such a thing as the Manson family, but a rather loose confederation of people who temporarily reside at what's known as the Spawn Ranch are the people I was referring to. And every time these people come to court as members of the public to witness the proceedings, the prosecution serves them with a subpoena and has them excluded from the courtroom. Now, if the prosecution legitimately intends to call these persons as witnesses, obviously we have no objection. But to say the least, these are hostile, reluctant witnesses for the prosecution. If anything, they could conceivably be defense witnesses, but certainly not prosecution witnesses. And it's our position that they deliberately subpoena these persons and exclude them from the courtroom so that they're not there while certain of their witnesses testify, namely Linda Kasabian.
You don't think they would try to influence her by looks, by signals, by standing in the courtroom and saying anything?
Well, I think the prosecution feels that the mere presence of some of Linda Kasabian's contemporaries and contemporaries of Manson and Van Houten and Krenwinkel would intimidate her. I suggest that if she's telling the truth, they don't have any problems.
Yesterday, you know, one of the family members, or one of the Confederate members, as you put it, did attempt to smuggle a note to Linda. And it seems to me that is a form of intimidation.
I'm not aware of that.
Yes, Sandra Good attempted to deliver a note to Linda on the 9th floor yesterday afternoon.
Well, I'm not.
Gary, yesterday one of the family members, Sandra Good, attempted to smuggle a note to your client, Linda Kasabian, which in my mind is a form of intimidation. Do you have anything to say?
Well, Mr. Knarrick's had quite a reputation for being an obstructionist. Do you think that's a pretty good description of the man's tactics in the courtroom?
I better not say anything directly on that, John. All I can say is this. You've observed him for 5 weeks. You saw his demeanor. And now the trial has really got underway, and I think you will agree with me that there's been a dramatic change between the Knarrick you saw for 5 weeks and the Knarrick you're seeing now. I think you'll all agree with me on that.
Can you speculate on his motives?
To speculate on the motives behind Mr. Knarrick's doing anything would be a rather unprofitable undertaking.
Is he laying groundwork for the appeal of this case?
Again, I don't know that. This might be his motive, but I think you'd have to ask him directly on that.
How much longer do you think Linda will actually be on the stand?
I expect that Linda will be under direct examination for at least 1 more day, perhaps 1.5 more days. Now, after direct examination, of course, there's cross-examination. Cross-examination might last a day or 2. After cross-examination, I anticipate that we'll have Linda on redirect for another morning or afternoon session. So Linda's going to be on that stand for a total of about a week. Let's face it, she is the proverbial star witness for the prosecution.
Vince, are you as far along as...
Vin, what is the particular purpose bringing out about the sex orgies at this?
As far as he was the one who was directing the entire affair.
Okay. Thank you, Vince.
Yeah.
Irv, I heard and counted 87 objections of yours to prosecution questions in the morning session, including objections to allusions to sex orgies at the ranch. Why so many objections?
Well, again, I prefer not to get specific because of the gag rule, the order that we not discuss matters that are before the court. But I will, but answering in a more general way. First of all, let me backtrack. I would be glad to go over with you when we get the actual record of these questions and answers, and let's haul down the books, haul down the rules of evidence, haul down the case law and the statutes, and see whether what has occurred is proper or improper.
I'm not making a legal judgment.
I appreciate that. The fact is, however, that if lawyers ask improper questions, then it's the obligation of the lawyer on the other side to try to do something about it. In fact, that's one of the techniques that a prosecutor has of getting a result at any price, no matter what, even though it's improper, even though the result is not a legal one. The prosecution has the power, by opening his mouth and saying certain things, to bring out certain material.
Now, you're the latest attorney to come into the case, and you didn't get to see any of the witnesses testify. When you argue to the jury, is this going to present problems for you?
Well, of course it is. Of course it is, because I'm in no position whatsoever to really comment upon the witnesses' demeanor, how they testified, the character of their testimony. I can't describe them. I can't comment on the manner in which they testified. I have to leave that to the jury because they saw them, and I have to beg the jury to in effect, do my job for me, which I'm helpless in doing.
Well, I'm going to concentrate mostly on the witnesses that testified against my client, Susan Atkins. Mm-hmm. And I think there's about 6 or 7 witnesses that concentrated on Miss Atkins and testified against her.
Irv Kenerick, what can we hear from you?
What's your question?
I'd like your opinion about Mr. Fitzgerald's presentation this morning. I'd like to know if it jibes with the other 2 gentlemen here. Also, I'd like to know, since you're Manson's attorney, what, if anything, you plan to tell the jury in particular?
Well, I'd like to say that that Mr. Fitzgerald certainly, in his argument to the jury, in this case, has shown that he deserves the reputation that he has for being one of the finest trial lawyers in this country.
Mr. Keith, number 1 question, how do you think Paul Fitzgerald is doing with his argument to the jury?
I think he's doing a very excellent job, a very thorough job. He's been very articulate, very dramatic in places, and I feel it's something that the jury is going to listen to attentively, and I do feel very strongly that that jury is impressed by the job he's doing.
Is that your client will have gotten a fair and complete trial out of this?
Well, I don't think I should comment on that. I think that's up to some other tribunal, perhaps.
All right. Mr. Shin, what is your comment on Mr. Fitzgerald's presentation this morning and on your own upcoming one?
Well, I think Mr. Paul Fitzgerald has done a wonderful job, and he's covering most of the main points. And I think he's going to be through this afternoon. Then I'll argue, and I'll probably take about 3-4 hours to argue.
Are there any particular points that you can tell us about now, or are you ethically allowed to do that before you actually present your case?
That what he is doing by way of argument is magnificent.
He looks tired and worn in there this morning, and as a matter of fact, none of you gentlemen look completely rested, and I'm presuming it's because of the length of this trial.
Well,
you work at night as well as daytime, I'm sure.
Yes, that's a very fair statement.
Uh-huh. Now, is there any particular thing that you'd like to comment on the fact that none of the defendants are in court at this time?
No, I don't think that because of the publicity order of Judge Keene and Judge Older, I don't think that I can comment upon. I don't think that I can fairly respond to your question.
Okay. Is there any particular thing you would like to comment on that I haven't thought to ask you?
Yes, I would like to comment upon the district attorney's continuing attempt to interfere with the fairness of this trial by the publicity that is finding its genesis right in the district attorney's office.
Now, I don't know if this will upset your case or not, but I think you got a heck of a good Christmas present there with that tie, Irv.
Thank you very much.
Thank you, gentlemen.
Thank you.
Morning, Charlie. Any comment at all?
I have a big laugh. Ah.
Bert, what was the reason for all 4 defendants being in court this morning when there's 2 different cases involved here?
Well, Dick, yesterday we went to the grand jury and secured a joint indictment in which the Hinman case and the Shea case were consolidated in one accusation. As a result, this is a new accusation which will eventually supersede the previously outstanding Hinman and Shea indictments.
Well, how can all 4 defendants be joined in 2 different cases when perhaps not all 4 are guilty of both crimes?
Dick, that's an excellent question. There is statutory and other legal authority for same. There are 2 bases involved here for the joinder. Number 1, it is permissible to join a case involving offenses belonging to the same class of crimes, such as crimes against the person. Murder would be one of those examples. Secondly, where you have different cases or different offenses involving different defendants, in which there is a common question of substantial importance, you are permitted again to join those offenses with the different defendants.
I'm on eavesdrop, Dick.
Day, your comment on the proceedings in Department 100 today.
The attorneys on that case didn't get any advance notice, and we didn't know when we walked into the court that they were going to consolidate those 2 cases. And I think the judge forgot that most of the defendants had attorneys, And when he consolidated, I don't think that he can wipe out attorney for the defendants. And that's why I made a motion to vacate the proceedings they had this morning in Department 100.
And you will continue to represent your client in these new pending cases?
Yes, definitely.
Thank you. By joining these cases, consolidating them, that it would save the county a lot of money.
Well, of course, this is the basis for the statutory preference. There is a code section which explicitly states that whenever possible, it favors joint trials. Were we required to try the Shea and Hindman cases separately, this would be a tremendous added cost to the taxpayers' very lean budget already.
Now, what actually transpired in court this morning?
Well, today we had Charles Manson, Bruce McGregor Davis, Steve Grogan, and Susan Atkins appearing for arraignment and further proceedings on the new consolidated indictment.
Okay, thanks very much, Bert.
Thank you, Dick.
Bert, Steve Grogan petitioned the court to represent himself, and you addressed the court on that issue. Now, what did you say and why?
Dick, I represented to the court that I was fully conversant with the evidence in connection with the Shorty Shea killing. I told the court that this case involves circumstantial evidence in the following manner. We have no body, and as a result of this difficult situation, we had to use every type of evidence that is available and admissible in the court of law. It's a very complex situation, and it involves building a very strong circumstantial chain. As a result of that representation to the court and other factors before the court ruled that Mr. Grogan was not competent to represent himself.
Now, how many witnesses did you call before the grand jury to lay this case out for him? Some 40 or more, I understand.
Yes, approximately 42 witnesses testified before the grand jury. Now, bear in mind that we even had to prove the corpus delicti of that crime wholly by circumstantial evidence.
If I recall correctly, this will be the third case that I know of prosecuting somebody without a body. There was the L. Ewing Scott case and the recently completed Devon case.
Yes, and I believe there was another Scott case which was prosecuted by one of our deputies, Bob Immerman, several years ago, and I think there have been several others in California.
I see. Thank you, Bert.
Thank you.
You've already got them on the shot.
Okay, well, this is it. All right. She's inside. You better light it.
Well, I would rather not couch it in terms of what the judge said. I'll couch it in terms of what the district attorney has done. The district attorney of Los Angeles County, despite the law of the state of California, despite the federal constitution, despite all that we know about where any defendant is entitled to a fair trial, the district attorney has deliberately injected pre-trial publicity in-trial publicity in connection with
Okay.
No, hey, let him get over there off the street.
Okay.
Bruce, come here. Don't get excited. It's okay, Bruce. It's okay. Hi, Bruce. Now let him get over here.
Bruce, can we ask you any questions at all? Like, for example, where have you been for months?
Well, I'm here now.
Well, could we ask you if you've ever been in Death Valley since the sheriff has launched several searches up there?
Why did you decide to come back now?
You look a little heavier than when I saw you last. Are you heavier? Have you taken on weight?
Mr. Bruce Davis, why did you decide to come back now? Why?
He would do it for...
I got you. Thanks a lot, Sim. That'll stop me short. That's good.
Well, we received some information this morning from a very close personal acquaintance of Mr. Hughes that Hughes contacted him on Thanksgiving Eve and asked for a ride to the Sespie Hot Springs area of Ventura County, which is a remote mountainous area. He said that he declined because his wife was 9 months pregnant, but that Hughes indicated to him he was definitely going to Sespie and was going to contact one or two other people for a ride. We firmly believe that he's in the area, although we're concerned with inclement weather conditions, and we're actually concerned for his physical safety.
What effect, if any, will his turning himself in, especially in a dramatic fashion like this, have on the case that you gentlemen are concerned with upstairs?
Well, we hope it won't have any effect at all. It's an unrelated case, unrelated events, and he's unrelated to the factual and legal matters in the case presently on trial. He's not unrelated to the defendants. He was a friend and close personal acquaintance. Everyone knows that, but he's not connected with our defense or...
I've been covering court cases for 25 years in this town. I've covered a lot of crazy ones, but nothing like this. What else new can happen in this one, Paul?
I don't know. I honestly don't know. It's an emotionally draining and fatiguing case. I get up in the morning and I ask myself what's going to happen today. It's been so bizarre, and actually, although I know a number of people think to the contrary, the attorneys in this case have made every attempt to make it into an ordinary conservative lawsuit and try it solely on the basis of the facts and the circumstances the prosecution had presented in their case, but it's just been impossible. Well, I think that's an intellectual possibility. The emotional reality to me is that he's simply isolated in some remote area up there, but that he's really all right. I certainly hope so. And the Sheriff of Los Angeles has been very, very helpful. They sent a search party up there, and they went through considerable efforts to make every attempt to find him, and I certainly hope they will, and I want to thank them very much.
How much longer can the events upstairs be stymied before the judge has to take some kind of action, and is there a chance for mistrial in this? Do either of you know?
There's a chance for a mistrial, and I would say that the case isn't going to be forestalled much more than 7 calendar days. At that point, we're going to have to proceed.
If you proceed, what can it be? The judge appointing another attorney for Ms. Van Houten, or will he simply declare a mistrial, or what will happen?
Well, there are a number of alternatives. He can declare a mistrial, in which case she'd be tried all over again in front of a new jury from the very beginning. Alternative number 2, I imagine, is to substitute in an attorney of her own choosing. However, that presents some almost insurmountable problems for an attorney coming in at this late date. Thirdly, I suppose the court could appoint an attorney in the event she didn't have funds to employ her own counsel. And I suppose, fourthly, she could represent herself and continue. I think that last possibility is not much of a possibility, in as much as that motion's already been made and denied. On the other hand, there are some tremendous problems in an attorney coming in at this late date and having to review all the testimony and not being faced with the witnesses, etc.
Day, is there anything you want to add to what Paul and you have already said?
No, I don't think I have anything to add.
All right. Thank you, gentlemen, very much.
you.
Oh, since you're a close friend of Ron Hughes, the mysteriously missing attorney, you must by this time be really worried.
Yes, I really am. I don't think that Mr. Hughes would have gone off out of Los Angeles and not notified someone unless he were in some kind of trouble or couldn't reach a phone.
What kind of trouble do you envision that he might be involved in?
Well, the only thing I can think of is that he's probably in nature somewhere where he can't get to a telephone and stranded.
Oh, you don't foresee any foul play or anything?
Well, I don't think there's any cause for that at this time.
Mm-hmm.
And, of course, it's possible, but I don't see any evidence of it.
When was the last time you saw Ron, and what did he tell you at that time about being in town or out of town?
I saw him a week ago Friday, the last day of the court session, and we had dinner together, and I told him at that time, he told me at that time that he was considering going to Sespe Hot Springs, and I told him at the time that I thought with the weather conditions the way they were that it might not be too good an idea, because the stream crosses the road up there, and during the rainy season it gets pretty wet.
Now, is there anyone else whom he might likely have left a message with or might have contacted since he's been gone?
Well, I've checked with some of his friends, and I haven't found any evidence of any messages. I found one message that was dated last Wednesday night, which evidently was on the door since that time, and that's the only one that I've come across.
A message that he left?
No, a message that someone left for him.
I see. Okay, what do you think will happen by tomorrow or the next day if he's not with us?
With regard to the trial, you mean?
Yes.
Well, I could only make an assumption there that wouldn't really be valid since I don't know, what the judge is going to do. I would assume the judge will either appoint another attorney or sever Leslie Van Houten from the case.
What's your full name?
Michael Green.
Okay, Michael, thanks very much.
You're welcome.
Hey, man.
Who would
You have anything to say to Charlie,
Are you talking
Bruce?
about Charles?
You have anything to say to Charlie?
You can't say that to Charlie.
Why? What do you mean you can't say that to Charlie?
Well, are you
Huh?
are you coming back here for Charlie Manson? You feel like you're helping him in some way?
Well, they want to kill bodies, don't they? Is that what they're after?
But how can you help by coming back now?
Can you give us a...
You're giving up for what? Why have you decided to come back now? What can
It's
you?
time.
Yeah, but why? Why is it time
Why?
now?
Give the answer.
What are you going to do?
Well, I'm just going to put myself here for right now.
But how can you help Charles Manson or anybody else? We're all together.
We're just going to say what's true.
What is true?
Don't look to me. Tell you the truth.
Bruce, you have anything to say generally?
Generally.
Yeah.
What's being done in exchange for you giving yourself up?
Whatever's being done.
Do you know what's being done? Have any deals been made, and if so, what are they?
Well, some people were supposed to be cut loose.
Who are they?
Who?
Mary Bruner, for one?
What is the deal?
How about Nancy Pittman? Is she being kicked loose too?
Are you going to testify at all during this current case trial? Do you plan to, Bruce, in exchange for Brenda's release?
Mr. Shin?
What do you plan? Do you have anything at all right now? We just want to know what it is that you feel that you can do now for Charlie Manson or for anybody by coming back now. Is it what do you feel that you can
arrangement
do?
have you made to bring him
What
in?
can you say?
What's been promised?
Well, as far as I know, nothing has been promised. The girls negotiated, and the girls had it brought in.
It's important that you showed up
Has there
at
been
this
any
time.
kind of arrangement made at all?
That I don't know.
Why was it decided in his best interest to bring him in, for him to come in, surrender voluntarily?
Well, that I don't know.
You know that you'll be facing murder charges?
Is that all?
But you do know that.
Well, who is it that
Well,
you...
they're putting murder charges on everybody.
Are you guilty of murder?
Are you guilty of murder? You asked the question.
Yeah, I'd like an answer.
Well, it's in you.
Well,
Don't look to me for your answer.
Well, you're going to have to defend yourself in court sooner or later. What will your answer be there? When you're arraigned, will you plead guilty or not guilty?
Guilty? Oh, that's your guilt. That's the guilt of who would want me to, whoever says it.
Who is it that you feel that you are helping or releasing or cutting loose by coming back?
Coming back.
Well, coming to here, coming to this corner today. Who are you cutting loose by coming here? You use that word, cutting loose.
I understand you got married in Las Vegas a couple of 3 months ago. Is that correct?
Man,
You said you were doing this for Charlie, is that right?
for Charlie, I'm doing it for me, man.
But what are you gaining out of it? What are you...
I'm just getting to do it.
You're getting to do what?
To do what I do.
Which is what?
Which is whatever I do, man. You just have to watch.
Where do you go from here right now? You expect to be arrested?
Excuse me, John.
I think you people have had enough. Let's go.
A dancing clown upon the wall is calling all to City Hall. Your grave is mine, oh can't you see? It's your own kind to be free. The truth I've known, you are the king. My love, this world to you I bring. You You know, you can be free. Look at your kind and come to me. I whisper words, you come to me. This song I sing for all to see. The past is gone and now I know, inside this cell, nowhere to go. Oh love, I love, look at your love. Oh love, I love, look at your love. My word, the truth in words you've never heard. Why do they fear and see in me? It's God themselves, I know you see. Oh love, I love, look at your love. Oh love, I love, look at your love.
Irving, first, Charlie Manson and his three female co-defendants are listening to final defense arguments in the murder trial from cells behind the courtroom. They're still locked out of the courtroom for misbehavior. Meantime, the 7-man, 5-woman jury is getting it firsthand from defense attorney Irving Kenerick. Do you have some idea when you will wind this up?
Well, the fact of the matter is that that what we're trying to do is trying to just get the highlights, and it's somewhat analogous to General Eisenhower. Just for an example, there's certain staff work that has to be done before you can start D-Day.
Day, I'd like your opinion of Mr. Kenerick's closing argument.
Well, I think that most of the subjects that he's covering now, I think was covered by Mr. Paul Fitzgerald when he made his closing argument. Mm-hmm. And I think that Mr. Kenerick is going into a little more detail, which I believe that is not necessary at this time.
I see. Irving Kenerick, Charles Manson's attorney, is in the third day of his summation to what appears to this reporter to be a bored jury. He is up to page 12,005 of a 30,000-page transcript. So far, he's covered the French Revolution, the Watts riots, the Chicago 7. He has quoted former General Eisenhower, Harry Truman, and several other politicians. Where he will go from here is anybody's guess. He's been accused of conducting a filibuster, and he says he is still not through. This is Dick Hathcock, Channel 5 News reporting. I want to say that I'd like for you to move over a little because I'd like my blue suit to show instead of yours. Irving, what page of the transcript are you on now?
Well, the actual page, of course, in preparing a final argument, it isn't, one does not progress seriatim through the transcript. What you do is you integrate issues, and that's what makes the task somewhat difficult.
Well, the only reason I ask is somebody has likened this to a filibuster.
Well, I think that, again, the filibuster is like we spoke about the genesis of an objection. The genesis of an objection is the original improper question. Now, the genesis of whatever you want to call a filibuster or whatever is the fact that the prosecution has put on a 6-month trial here. In fact, there has been nothing by way of because of the presumption of innocence and the fact that the prosecution has to prove their case, which some people don't believe necessarily has occurred.
Do you believe that the prosecution has failed to prove a case against Mr. Manson?
Well, I'd rather not get too explicit about it. But the fact is, nevertheless, that have a situation where the jury, they are people that have to more or less go through this horrendous record. And actually the time that's involved in this, in what's been going on here, actually it's just a couple of days.
Let me ask you this now. Yesterday, Charlie shouted at you to sit down, that you weren't proving a point or some such thing. Did this throw you off at all? Does it distress you when Charlie injects himself into this?
Well, again, my subjective feeling is really that's not important. Harry Truman made the statement, if you can't stand the heat, stay out of the kitchen. And law is a very unusual process.
And you're a very unusual attorney. Thank you, Irving.
Thank you.
Irving, the prosecution has pinned their opening.
Actually,
Irving Canarick, Charles Manson's attorney, is in the third day of his summation to what appears to be a rather bored set of jurors. Let's do this over.
Ship it and sink it.
Well, everybody's quite concerned. A number of lawyers have come up and are very, very critical of the procedures. Even lawyers are searched, their briefcases are looked into. Every person who walks in the building is searched. When you inquire of the sheriff says to discuss it with the court, and when you discuss it with the court, they say that it has something to do with sheriff security, and you're right back where you started from. So they won't discuss with you the basis of the security problem. Mm-hmm. So it's difficult at this point to blame anybody or question anybody's motives, because they simply are not in possession of any of the facts.
I see.
Well, we're a little miffed about that, that we're not told the nature and character of the threat.
Paul, what effect, if any, does the rigid security, both here in the building and the police escort of the jury, have on the possible verdicts the jury might bring in?
Well, all the defense attorneys are becoming increasingly concerned that the effect of the security is going to be to intimidate and coerce the jury. The jury must feel that they're under some danger of death. And the rumors that have been circulating are that some harm is going to come to the jury if they don't convict the defendants. Mm-hmm. And there's supposed to be some threats or something from the Manson family, but that appears to be preposterous, because there isn't anybody left of the Manson family. Everybody's in jail except for about 3 girls kneeling on the sidewalk outside. Mm-hmm. We're terribly concerned that this jury they're here to decide whether Manson is a murderer, and these girls are murderers, and if they feel their life is threatened by these people, they're going to have a very difficult time acquitting them.
Well, perhaps this puts you on the spot. If it does, just to say you know what I answered, but do you see this as a deliberate ploy by the DA's office to maybe influence the jury, or do you think this is jury's request to hear one of the Beatles' records?
Well, it's difficult to tell. There was a considerable amount of testimony relating to the album. They do have a set of lyrics, written out lyrics, but of course there's at least one selection on the record that doesn't have any lyrics at all. It's Revolution 9. It's a selection that has in the background machine gun fire and screams and has some violent revolutionary overtones. Mm-hmm. I hate to attach any significance to it at this point. I think they're just attempting to make an independent determination and evaluation of the evidence, and they haven't heard it, and I think they simply want to hear it.
Is there any indication that anything else is sort of hanging them up?
Not yet. We just, if the jury comes back into the courtroom and they ask more pointed questions about some of the items of evidence, then of course we can get some sort of indication of perhaps, of how they're thinking, but so far you just can't tell.
This would be the jury's third full day of deliberation.
Correct. They started Saturday.
If those jurors had pretty well made up their minds at the conclusion of this trial, guilty or innocent, what do you think is holding them up? Is it so involved a thing, so many counts on so many persons? Could that be holding them up, or why haven't they come back with a verdict already?
Well, you must remember that they listened to about 80 witnesses. There are about 500 individual physical items of evidence. There are approximately 77 different verdicts. Remember, you have 4 defendants, you have 8 counts. I think, and the jury, of course, was instructed that they couldn't discuss it amongst themselves throughout this entire trial. This is the first time they've had to talk to one another about it. It's the first time they've had to actually review their notes and review these physical items of evidence. I think it's proceeding in a very normal fashion. I doubt that the first thing they would have done would be to go into the jury room and take a ballot. I think what the more likely, they've gone into the jury room and they're going through this evidence piece by piece, and they're reviewing their notes and the testimony of the witnesses before they do anything. I would suspect they haven't even taken a ballot on innocence or guilt yet.
If I were to make a prediction all on my own that the jury is going to be a hung jury, what would you say?
Well, it's very difficult to tell. I'm in possession of so little information, of course, and no one's back there in the jury room, and you don't know. I think in a case like this, where you have a tremendous number of witnesses, a tremendous number of physical exhibits, where the trial's been lengthy, where the trial's been controversial, you always have the possibility of a hung jury. But at this point, I don't think we can say there would be a hung jury. If they deliberated a week and a half, I think that would be a distinct possibility. But at 3 days, it's very, very difficult to say.
Thank you, Paul.
You're welcome.
Beautiful, Paul. He looks like a professional. Beautiful.
A tight ring of security surrounds the Hall of Justice today as the Manson jury deliberates. Both the Spring and Broadway Street entrances are being used, but sheriff's deputies are on guard to search everyone entering the building. Briefcases are opened, parcels, packages, and purses are checked. Everything carried into the Hall of Justice is closely inspected. The heavy security started Friday evening, continued over the weekend, and will last probably until the jury returns with a verdict. Meanwhile, 3 members of the Manson clan continue their vigil outside the Hall of Justice at the corner of Temple and Broadway. They've been there since the start of the trial. Sheriff's officials refuse to state why the extreme precautions are being taken. Judge Older, who's conducting the Manson case, has ordered that no comment be made. However, it has been known that threats have been received and every precaution is being taken to protect the jurors. It was only last September 7th that a bomb exploded near the office of the district attorney in the Hall of Justice, doing considerable damage, but fortunately no one was injured. From the Hall of Justice, Stan Chambers, Channel 5 News, reporting.
Yeah, I think they'll be hung. They've only seen one side of the story. So, with only seeing one side of the story, it's pretty hard to make any kind of a decision.
Have any of you ladies been in contact with Charlie or the other girls and gotten any opinions from them on the jury?
No, we haven't. Like, if they could put on a defense or speak, then everybody would be able to see, you know, their side of the story and what they have to say. But they haven't been given a chance to say anything, and it's their lives that are on trial.
One final question. If, and I say if, Charlie were convicted of these charges, which means that he would at least be in jail for a long time, what happens to the rest of the members of the family? Where do you go? What do you do?
We all go to the desert. There's no if. Charlie will get out. All the people in jail will get out, and we'll all go to the desert together.
We will. Sure. Today is the 6th full day of deliberation by the Charles Manson murder jury, with no indication whatsoever that the 7 men and 5 women are about to reach any accord. This is take 2. Today is the 6th day of deliberation by the Charles Manson murder jury, with no indication whatsoever that the 7 men and 5 women are about to reach any accord. Security at the Hall of Justice is extremely tight. The press corps sitting in Judge Older's courtroom play cards, work crossword puzzles, do a little knitting, and a little sleeping. Today we're talking with some of the members of the Manson family who have maintained their vigil here unceasingly for several months. Hi, Brenda.
Hello.
Well, let me see some of the knitting that you're doing there, whatever you
it's
call
embroidering.
it. Oh, I'm sorry. I'm not hip to that.
It's just with colored threads, and this is a vest that all of us girls, all the girls in jail, and all the girls here on the corner have worked on for 4 years. And it's
worked on
Charlie's
it for 4
vest.
years?
Yeah, it's his biker vest. He wears it when he rides bikes and dune buggies and whatever he does.
Well, all of you ladies have worked on this.
Yeah, all of us. Sadie and Leslie and Katie and Squeaky and Uish and Gypsy and us 3 and Cappy and everybody.
Well, is it about finished?
Well, we're going to line it, the whole entire thing, with the same sort of thing. This thing here, which Kitty's been working on for a year.
That's beautiful.
It's a Phoenix bird.
It looks extremely intricate. Is that why it takes so long?
Yeah, it's done with maybe 1 thread at a time or 2 small threads at a time, and it's just whatever our imagination, wherever our imagination goes is where the threads go.
Does it tell a particular story?
Not really, except for an imagination. There's anything in there you wish to see.
Now, I see you have a hand here. Could we hold that up to camera and see that? And does that go on the jacket somewhere?
This is going to be part of the lining.
Oh. Now, does this have any significance, the hand part?
No, it doesn't. It's just consists of people and women and babies and...
Speaking of babies, I understand that there's a move afoot to take Gypsy's baby away from her.
Yes, it's one of their ploys to take the babies away and then threaten the girls with never seeing them again to get them to testify, you know, on the prosecution side to some sort of story that they, you know, lay out for them.
Well, do you know any of the details on the county or state trying to take Gypsy's baby?
No, they went to a hearing today at 8:30 on it, and all I know is they've been subpoenaed for a penalty phase, which means, obviously, penalty meaning take away the baby, which they've tried to do to everybody in this case.
Well, is there any move afoot to take Pooh Bear away from Mary?
Well, Mary's parents are best friends with the judge over in Wisconsin, and they've gotten legal custody of the child and termed her. They said that she didn't take care of him, yet she was in jail. You know, she couldn't have taken care of him while she was in jail.
Sure.
So,
well, now, what do you ladies think about the jury being out so long? Does it offer any hope? This is Dick Hathcock, Channel 5 News reporting. Your client got a little rambunctious.
Well, it's whatever happened because of the attorney-client relationship. I have an obligation to him that is that I cannot discuss.
Let's say maybe I saw it.
All right.
Is that possible?
Well, whatever you saw, you saw. I mean, I can't. I don't think that it'd be incumbent upon me to discuss anything that might go to the disadvantage of anyone I represent.
He also shouted through the cell door back there for you to shut up and sit down. Does this disturb you in your carrying on this case?
Well, like I think we've discussed on other occasions, the attorney-client relationship is somewhat like the husband-wife relationship. Everything is not always
what the neighbors
sweetness. That's right. It isn't always sweetness and light.
I might say this, that I saw what happened between Mr. Manson and Mr. Kenerick in court there, and I believe now that it was just a love tap. It's nothing offensive to Mr. Kenerick. It was just a love tap.
It's sort of like between husband and wife, as Mr. Kenerick said.
That's correct. It was just a
sort of to get his attention.
Right, a little dispute, and Mr. Kenerick was talking, and he was just pulling on Mr. Kenerick's arm to get his attention. It was just a love tap, believe me, gentlemen.
Was in there this morning. Did he actually rap you on the shoulder?
And because someone is a client doesn't mean that they are like a rock or just a eunuch.
Does it disturb you when your client does this?
Well, that's part of the practice of law. I mean, one of the as we've discussed before, this is one of the things. People who are lawyers do not always agree with people who are clients. And
Mr. Kenerick, what did Fitzgerald ask for a plea of insanity for his client at this late date?
Well, I rather than get specific, let me put it this way. There is a plea that's recognized and not guilty by reason of insanity, and Mr. Fitzgerald, as an attorney, saw fit to attempt to have that plea entered at this point in the proceedings. I would gather that we can argue certainly that forgetting this particular case, that the mental state of Ms. Krenwinkel or any litigant is probably something to consider in the penalty phase.
You're also asking for...
Why did she reject it?
You'll have to ask her and Mr. Fitzgerald.
You're also asking for an investigation of one of the jurors on the grounds that she may be a little bit nutty and perhaps a heavy drinker. Is this true?
Well, there have been papers filed in the court, and there may be a hearing on this matter. I would like to state that I think that all of us, when we are defendants and when we're members of the public or whatever, all of us have a right to have jurors who are of an impartial mind and who have capacity and all of that to judge a case. And I think that it wouldn't be proper for me to discuss the details of what you're referring to at this time. However, I can state that there was, I mean, this is a matter of public record, over Channel 9 on January 21, 1971, there was an interview with Mr. Hines, who was and is the husband of Mrs. Hines, who is on this jury. That's a matter of public record.
Now, is Mr. Manson going to take a stand and testify?
Well, I can't discuss, because not only because of the publicity order, but because of the attorney-client privilege.
Day, will your client take the stand? Do you know? Have you discussed it with her?
Yes, I believe she'll take the stand. And
yeah, I would think that the people out there in the public would be more interested in the substance of what happened in the courtroom today. There was a witness on the stand, Mr. Crow. Now, it would seem to me
the fellow known as Lots of Papa.
Well, right. Now, it would seem to me that we would be performing a service for all of us if we had if we would make available the detailed testimony of Mr. Crow. Now there is
well, he has just testified that Mr. Manson shot him.
Well, but they're assuming, arguendo, that what you're saying is correct. There are other aspects of his testimony which I think are very important as far as inferences in this case are concerned, and I think that it would behoove us all to read the actual testimony of Mr. Crow before we make any judgment concerning Mr. Manson. After all, the case that's on trial is the Tate LaBianca case.
Mr. Shin, Mr. Fitzgerald moved an insanity plea for his client this morning. Why didn't you choose to join in that?
Well, I felt that at this late time, there was no necessity for it. Now, at the end of this plea, I think we should have entered it before the trial started, and not at this late date.
Why didn't you?
Well, at that time, I don't think it was necessary.
Why?
There was no indications that we needed that plea.
Would this be an admission tantamount to confession day?
No, I mean, at that time, I felt that after talking with Miss Atkins and her background, that there was no need to enter a plea by reason of insanity.
But do you wish that you had?
No,
If I may, I'd like to make a statement. When Mr. Shin says we, he is not speaking for me by any manner or means. When he says we, I would assume he's speaking about himself and his client. I don't want anyone to think he's speaking for me at any time.
Irving, are you going to enter
between Mr. Canarik and Mr. Manson?
Well, like Mr. Manson said, there was no communication, but I believe there is communication, and they're just fighting like cats and dogs.
But Irving, are you going to enter a insanity plea for Manson by chance?
Oh, I wish I could answer that directly. This is what Mr. Fitzgerald did. He did on his own, on behalf of his client, and there's no pertinency whatsoever to anything that I'm going to do.
Have you ever thought of entering an insanity plea for Manson?
Well, you see,
you're a good lawyer now.
No, that's when have you stopped beating your wife type of question. That's exactly what that is. There is Mr. Manson, what his state of mind is and so forth is strictly, as far as the public's concerned, as far as all of us is concerned, is a matter of sheer propaganda and publicity by the district attorney's office and by the mass media. We wouldn't be here with all of these TV cameras and all of that right now, except that it was a structured type of situation to put Mr. Manson in a bad light.
Well, you said that last week, but again, Irving.
Well, it's true. The sun rose today.
Thanks, Irving.
The sun rose today, and it rose last week. That doesn't mean that it isn't right.
Irving, you talk to me better outside the jail than you're doing here. Irving, did you consider entering an insanity plea for Manson again? Let's stick to the point.
That is assuming, that is a when have you stopped beating your wife type of question. That assumes there's something wrong with Mr. Manson's sanity. I mean, obviously, this is ridiculous. It's like,
Irving,
you just can't ask that question.
That's why you're a good lawyer. Son of a gun. Did you say yes or no?
I'm saying that your question is not a proper question because it assumes matters that are not even in issue.
Irving, how can you say that?
Why did he shoot you? How long have you known Charlie Manson? How long did you linger between life and death?
You guys, nobody thought of Charlie?
I don't think we asked. I've been told that Charlie Manson shot you. Is that true?
Could be.
Well, let's not kid each other around now. It's either true or it isn't true. Did he shoot you? And if so, when and where?
Yes, he shot me, yes.
When did this take place?
August the 1st, 1969.
on Franklin Boulevard, next to the Magic Castle apartments.
In an apartment house?
Yes, an apartment.
Well, now, why?
I refuse to answer on the grounds I mean.
Well, is there some reason why you'd rather not answer that?
I'd rather not answer that question.
Well, let me ask it this way. Was it a personal dispute of some kind, or what?
Yes, sort of, yeah. It's personal dispute.
Well, was anyone else involved?
Yes.
Well, who was that?
Charlie Watson.
You mean Tex Watson?
Yes, Tex Watson.
Well, were you having a dispute with Tex and Charlie interfered, or how did it happen? I don't mean to push you on this, but since you have admitted that he shot you, I'd like to know why. Well, you were having a disagreement with Tex or with Charlie, and out of this grew the shooting. Or awareness is through fear?
Yeah, one or the other. Fear through awareness, or awareness through fear, something to that effect.
Now, Charlie Manson said this?
Yes, he said that, and he walked out.
And he walked out without his shirt?
Yeah, he walked out, and he took the shirt of my friends.
I see.
With him.
What kind of a gun did he shoot you with?
From looking at it, it was just... just a revolver.
A revolver?
Yes.
Uh-huh. Well, without going into any further detail except for caliber, what caliber was it?
I will not comment on that.
Oh, all right. Now, how seriously were you shot?
Pretty seriously, critical. My heart had stopped twice on the operating table, and well, they had sent telegrams to my family telling them that they don't think I would make it. In fact, I still have the bullet in my back.
You still have the bullet in your back?
Yes. They said it's in a muscle and it formed a scab over it. And they didn't want to take it out. I believe it was kind of close to my spine, the reason why they didn't want to take it out. And also, I like to have that bullet removed from my back.
You would like to have it removed? Why would you like it removed at this point?
Well, actually, it could do me bodily harm. As medical terms, that I've been advised that it could
cause some future problems?
Yes, in the future, as far as getting in my bloodstream, a poison from the lid.
I see.
After a certain of time. I've been informed by medical...
Well, if you had this bullet removed, would you turn it over to the police authorities to compare with the weapon that Charlie Manson has been accused of using?
I will not comment at this time.
Can you tell me how long you knew Manson and Tex Watson?
No comment.
Okay, now without perhaps...
So I say that same night I met him. Same night.
Oh, I see.
The very same night.
Now, were you introduced to them by a third party, or?
Yes, I were.
Okay. Now, without going into it, I suppose there was some kind of a business deal going on, and as happens, there are disputes in business and that sort of thing.
I will not comment on this time.
Okay. What is your feeling about Charlie Manson at this time?
Well, my feelings for him is, I believe that I feel that he's I think that
How long did you linger between life and death?
I couldn't actually pinpoint it, but I know several times that I attempt to get up and to move around, and then I had collapses. I cannot really pinpoint. I know I was in the hospital for 18 days, and I say the majority of those was pretty critical.
Yeah.
But I just felt it would take as much courage to die than to live.
Now, I know you by the name of Lotsa Papa. Where did that name come from? How'd you get a moniker like that?
It seems like everyone that I meet seems that I seem to be a daddy to them, more or less, because I'm always trying to give some sort of advice, I guess, you know. But I don't practice what I preach.
What do you weigh? You look like you weigh about 230, 240. Is that maybe where it came from? You're Lotsa Papa?
Yes, about 293, more or less.
That much?
Yes. It was just that there were friends of mine that named me that, Lotsa Papa. Yeah.
Well, I think they'd have to be a friend to get away with it.
Yes. Well, I think it was said out of divine order. I mean, it's beautiful. I consider it a pet name.
Yeah. Well, now, is there anything that you want to tell me that I haven't thought to ask you about?
I don't believe so.
Well, now, I understand that you do a little writing, and you could, if somebody was interested, collaborate with them on a magazine story, or perhaps a book, or even sort of a technical advisor for movie stuff.
Oh, yes. Yes, I'm ready for all of that. I am capable of doing acting or whatever. And as far as the story is concerned, I wouldn't mind giving it to any magazine who'd like to have it.
Well, it's been a pleasure talking with you, and I know I had to drag some of this out of you, and I hope you're not sore at me about it, but that's my business.
I know, I felt those that thought plus belief equals manifestation is my thought. And whatever happens to me, it was because of me, no one else but me. So you're just doing your job.
Thanks very much.
I can cooperate with you.
I appreciate it. Thank you.
You've heard the verdict. How do you feel now? What are you going to do now?
You've all judged yourselves poorly.
Are you guys proud of a system where a man cannot defend himself? Are you proud of it?
That was an 8-month trial with many witnesses. What are you going to do now?
That was a trial, 8 months of prosecution testimony. They've convicted these people, and you are next, all of you.
What are you
There
doing?
are many.
What are you going to do now?
Listen to me. There are many more men who are experiencing the same injustice. There's a revolution coming very soon.
What would you do next now? What are you going to do right now?
We're going to stay here until Charlie's out.
Looks like that will be never.
He'll be out. All the people will be out.
What makes you so sure?
Angela Davis will be out. Bobby Seale will be out. There's a revolution coming. You've all judged yourselves.
What gives you this faith?
Sit here until they get out?
Yes.
You've never heard. Why do they fear unseeing me inside yourself? I know you see. Catch your love.
Revolution.
Soon.
When is soon?
Very soon.
Weeks? Months?
You'll know. You'll know. You'll see it.
You'll probably be out there trying to televise it until he comes out.
Did you expect this verdict?
The verdict doesn't make any difference. It's what has led up to the verdict. He has not had a fair trial. There are many more men who are not having fair trials. They've hid us word from you. Charlie hasn't been able to speak in the courtroom. The defendants haven't been able to put on a defense. They've thrown the Constitution in the wastebasket. Where does that leave your law? It's anarchy. Total anarchy is
Do you
coming.
plan to continue to sit here indefinitely?
Yep. We'll be
How
here.
long?
However long we're here.
What do you plan to accomplish by sitting here?
We're waiting for We're waiting for those penitentiaries and those jail doors to open.
What's going to open them?
The revolution.
What do you mean by a revolution?
A bloody revolution.
You going to be part of it?
Oh, I'll have a part, maybe. I'll do whatever I do. Want to take the children to the desert?
Did the verdict come yet? What is it? A little more.
I'm stuck. My feet are...
Were you surprised by the verdict, Mr. Fitzgerald?
Well, we were disappointed by the verdict. We anticipated the verdict. We all anticipated the verdict, but we were disappointed nonetheless when it came. We felt that we lost the case when we lost our change of venue motion. We felt we had about as much chance of winning this case in Los Angeles in 1970 as Sam Shepard had in Cleveland in 1950.
Could you have won the case outside of Los Angeles?
Yes, I think we could have won the case outside of Los Angeles. I think we could have won it as to each and every defendant.
Why do you say that, Paul? Why do you think you have no chance here?
I think that we were forced to select a jury from a very hostile and antagonistic community of Los Angeles. We wouldn't have had those problems if we would have been able to select a jury someplace else.
Do you have any regrets of not having presented a defense?
No. I thought about that very carefully, and we don't. At least I don't have any regrets about. We tried it the best possible way. We tried to win, actually. Hope springs eternal in the human breast, I guess. We tried very, very hard to win.
The district attorney's office and I personally and the Los Angeles Police Department are very, very pleased with the verdict. That goes without saying. We're all very, very happy.
Is this what you expected?
Yes, definitely.
There were no surprises, apparently.
Absolutely not. We put on a monumental amount of evidence against each defendant, and it was our belief that the jury could only come to one verdict, guilty.
What about the penalty phase?
About the verdict at any point?
No. I want to say that this jury came back exceedingly swiftly. For a 7-month trial, they were only out 6 days. This is very, very quick. Very quick.
The penalty phase now?
We've subpoenaed over 50 witnesses. This does not mean that we're going to call all 50 witnesses to the stand. I'm going to have to make that determination within the next day or so. There's a very strong likelihood that we will put on a very short penalty hearing.
This is the arena, and this is the day after. For 8 months, this courtroom has been crowded. Hundreds of persons have stood outside in line waiting to get a seat. 84 witnesses have paraded to that witness stand and given their testimony. 30,000 pages of testimony have been recorded in this case, hundreds of exhibits shown. Yesterday, the 7-man, 5-woman jury reached a decision on the ultimate fate of Charles Manson and his 3 female co-defendants. Guilty of murder, guilty of conspiracy, all of which carry a possible death sentence. But today, this courtroom is like an old fighter in the 9th round of a main event. Weary, empty, one more round to go. And there's one more round to go in this case, the penalty phase. This is Dick Hathcock, Channel 5 News reporting. This is the arena, and this is the day after. For 8 months, persons have crowded this courtroom. Hundreds of persons have stood in line for hours trying to get a seat in here. But yesterday, This is the arena, and this is the day after. For 8 months, this courtroom has been crowded every day. Hundreds of persons have stood in line outside waiting to get a seat in here. 84 witnesses have paraded to that witness stand, given their testimony. 30,000 pages of testimony have been recorded, hundreds of exhibits. There have been fights in here, there's been lots of drama, excitement, lots of name-calling, bickering, high drama. Yesterday, the jury of 7 men and 5 women reached a decision on the ultimate fate of Charles Manson and his 3 female co-defendants. Guilty of murder, guilty of conspiracy with possible death sentence. Today, this courtroom, this arena, is like a tired old fighter going into the 10th round. He may come up for the 10th, he may not, but this arena will see some more action, probably in a few days' time. This is Dick Hathcock, Channel 5 News reporting.
Well, at this penalty phase of the trial, this second section of the trial, any evidence in mitigation of the offense is admissible to determine whether or not the defendants ought to live or die. And we certainly intend to put on some information about the defendants concerning their background and history, where they went to school, what their childhood was like. We intend unquestionably to put on parents and relatives of the defendants. In addition, there's been a tremendous amount of controversy during the course of the trial about life in the Manson family. We intend to put on people from the family to testify about the defendants and about life in the family. We also intend to introduce some evidence that would indicate that the defendants may not be entirely guilty of the offenses themselves.
Who starts the drive to save the life of your client and also the lives of the other co-defendants in the Charles Manson murder trial? Do you have a game plan, so to speak?
Convicted these defendants beyond a reasonable doubt, but one of the standards we are going to suggest to the jury is that if they're going to vote to execute these people, they ought to be absolutely certain that they committed these offenses. And we would want to put on some aspects of our case that we didn't put on during the guilt phase of the trial. We also anticipate that perhaps one or more of the defendants themselves would testify.
This then essentially will be a sort of a four-part, this is your life type thing.
Right.
This is your life, Patricia Krenwinkel.
Right. In order to assess, probably the most important decision anybody can make in their life, probably a decision most of us wouldn't like to make, whether or not another human being should live or die. If we're going to make that kind of decision, we ought to really have as much information at our disposal about the person we're talking about. Then we ought to know as much as humanly possible. We ought to do some sort of this is your life.
Have you had any kind of problem in inducing relatives of these defendants to come to court and tell their stories?
I think that the close relatives of all but one of the defendants, and I have particularly in mind Charles Manson, the other close relatives have actually been very, very loyal. I think the only reason they haven't been in the courtroom itself during the guilt phase of the trial is that they want to preserve what's left of their private life, and they just don't want to be exposed to the publicity. So as far as the close relatives are concerned, some of the past employers, some of the people who knew the defendants peripherally, some who knew them casually, and some of the more distant relatives have been extremely reluctant to give information in connection with the defendants and certainly to testify.
Do you know off the top of your head who among the defendants will take the stand?
Well, it's difficult to determine at this time, but it appears likely that Manson will take the stand. It appears likely that Susan Atkins will take the stand. It appears unlikely at this time that Leslie Van Houten and Patricia Krenwinkel will take the witness stand. But of course, that obviously is subject to change, and we'll certainly evaluate the situation as it occurs. And then, of course, in this case, of all cases, things aren't very certain.
In putting any of the defendants on the stand, this does open them up to cross-examination. Now, can the prosecutor go into any subjects which were not, which he was not able to go into during the guilt phase of the trial?
Yes, and that, of course, is one big tactical reason why I think attorneys are reluctant to place their respective clients on the witness stand during the penalty phase, because if the client doesn't, or the defendant doesn't demonstrate the requisite amount of remorse or somehow doesn't come off, and of course he's subjected to what I would suspect in this case would be a painstaking, thorough cross-examination. It could be very, very dangerous. On the other hand, the contravailing reason, I suppose, is that one of the very good ways to tell a jury what somebody's like is to let them be exposed to that person, let that person talk and actually communicate directly. It's difficult to do it through a third person.
Have any of the...
Do it again, Dick, please.
Yeah. Paul, have any of the defendants demanded to be allowed to testify in the penalty phase?
Well, the answer to that is yes, but I think that I ought to explain it a little bit. Certainly, all the attorneys in the case listen carefully to the desires of their clients, and recently, of course, the defendants have indicated very vociferously that they intended to testify at the guilt portion of the trial and intended to put on a defense, and they're adamant in those demands to the present time. The issues now at the penalty phase are substantially different than they were, and the countervailing factors, of course, aren't the same. In essence, their life is at stake, and should the defendants wish to testify in their own behalf, I think every doubt would be resolved in their favor, and that certainly we as attorneys would allow them to testify. Now, at the present time, there's been no indication on the part of Leslie Van Houten or Patricia Krenwinkel, my clients, that they want to testify, but should there be, they certainly would. I think Manson actually indicated in open court that he wished to testify, and I think that it's probable that he will testify. I also think it's probable that Susan Adkins will testify, because her attorney, Mr. Shin, has indicated that she has indicated a desire, and he's going to certainly allow her to testify.
What will happen tomorrow, mechanically or physically, I should say? What happens tomorrow?
Well, tomorrow, of course, the penalty trial opens, and I imagine there'll be some preliminary motions and some preliminary discussions. Then the prosecution will begin their case. They will present evidence in aggravation of the offenses, and they'll present evidence concerning the defendant's background and history.
I see.
And they're asking for the death penalty. I think it's a very inappropriate sort of statement that the prosecution's asking for the death penalty, but nonetheless they're going to urge the jury that the defendants ought to die, and they're going to introduce some evidence in substantiation of their request. We're unable to determine how long the prosecution's case is going to last. We get varying estimates, some a week, some 2 weeks, some as long as a month. But at the conclusion of their case, of course, we will present evidence, and then we'll follow the same formula. There'll be argument, and then jury instruction, and then deliberation.
So the penalty phase could conceivably last a month, perhaps even longer.
It could last a month, even longer, and I think that as one looks back over this case, the lawyers have been notoriously inaccurate in terms of predicting the length of every portion of this trial. I think that I personally have misled a number of people as to how long this trial is going to last, so I'm a little reluctant to make estimates, except that it's likely to last longer than anybody anticipates.
One final question, Paul. In the event that your client and the other clients are given the death penalty, what happens then? There's an automatic appeal review of the case, and then what?
Right. As you indicate, under California law, under Penal Code Section 1239, the case is automatically appealed directly to the California Supreme Court rather than an intermediate court of appeal. And it's done whether the defendants like it or not. It's an automatic review. The California State Legislature feels that in a situation where somebody's life is going to be taken, that there ought to be a very careful review of the legal proceedings. I think a rather lengthy appellate procedure will follow, and I think that considering all the appellate remedies and avenues of appellate approach, that it would be at least 5 years before there would be a firm execution date set.
Thank you, Paul.
Welcome.
Paul, have any of the clients or your client demanded to take the stand and testify in the penalty trial? Let's do that again. Paul, have any of the clients or has your client demanded to take the stand and testify? Hold on a second. Have you had any trouble inducing any of the relatives or friends to come in and testify in this penalty phase? In the event your client and the others are found, no. In the event your client is given the death penalty and the other clients also, what happens then? Is there an automatic appeal?
As the chief law officer of the state, there's been many comments about the length of this trial. Do you have anything to say about that?
It's outrageous. I mean, of course, I'm not. That's no criticism of the judge. He's doing everything he can to control it. But again, without reference to this case, our system has deteriorated to the point where the trial of a criminal case is more like a circus than it is a judicial proceeding. And I've said and will continue to say we have to perform major legislative surgery on the system or it's going to collapse.
Mr. Attorney General, it's nice to see you here today.
Good to see you.
What are you anticipating in this trial? Why are you being called and by whom?
I understand that Mr. Kanarek has had a subpoena out for me, and I just want to make it easy for him. I haven't the slightest idea what we're going to talk about, but I'll be happy to see you in I was going to say a few minutes, but that's not very realistic. I'll see you when I'm through.
Thank you.
I don't think there is any such thing as ordinary in a case like this. Thank you. Excuse me, gentlemen, I'll be with you. Hopefully, it's over this way, guys. Down there. Get it.
Mr. Younger, what do you have to say about this morning's testimony?
Well, most of the questions addressed to me involved a meeting which was held in the District Attorney's Office on December 4th, 1969. The meeting was attended by members of what was then my staff in the District Attorney's Office and by attorneys representing Susan Atkins. At that conference, a certain agreement was reached with respect to what the prosecution would do in certain circumstances. Immediately after the conference was over, I asked Mr. Stovitz to prepare a memorandum covering the conference. He did so. The memorandum was prepared and is now in evidence, and if you gentlemen would like a copy, you may have it.
Why did you decide not to continue to offer the arrangement to Miss Atkins? Why did you decide to change that and seek the death penalty?
I testified to that in court this morning, and I'm not certain whether the judges would consider my repeating my testimony and that to that question as proper or not. So out of an abundance of caution, I won't answer it, but I will invite your attention to the transcript where I did precisely answer that question.
Has the prosecution
that your office in any way violated the agreement that it had with Miss Atkins and her attorneys?
No, sir.
Why?
For reasons I stated in court in the last couple hours.
Do you feel that Miss Atkins was not telling the truth?
Again, I answered that very precisely from the stand, and you'll have to forgive me. I don't want to get involved in any argument with the judge over semantics. It might be argued that since I testified in there, I ought to be able to repeat it now, but I'd prefer that you refer to the transcript.
It's always been the practice, Mr. Younger. It hasn't been considered a violation of the gag order.
Well, I probably might be subjected to a little more strict interpretation of the rules under the circumstances, and that's so long as I did answer it all on the transcript, why, I think I won't again.
Do you feel that your questioning was, your answers were rather evasive?
This morning?
Yes.
You gotta be kidding.
Mr. Younger, you testified that you studiously avoided reading any publications concerning the Tate LaBianca murder case. Why did you choose to avoid reading about the case?
It's very unpleasant reading. I have a number of things which I had to do as Attorney General, and, or rather had to do as District Attorney and now have to do as Attorney General, which require me to read hundreds and sometimes thousands of pages, often with regard to very unpleasant, very gruesome, very bloody activities, and I do that to the extent that it's required, but rereading about these same things in a newspaper just when I'm presumably on my own time and have some choice as to what I want to read is not my idea of a pleasant postman's holiday.
At the time of the Susan Atkins confession, the publication of that confession in the Los Angeles Times, did you make any effort to find out how the Times had gotten a hold of it and then printed it in light of the fact that you were the county's chief law officer and a gag order had been issued by the court?
No, sir, it was not my gag order. I didn't make any attempt to find out how the Times had gotten it. And again, as I explained, I've explained this many times. This has no reference to the present case. One of the troubles with a gag order is that a judge can write any kind of an order he wants to, but a defendant in a murder case is not going to pay a blessed bit of attention to it. What are you going to do to a defendant who's may be sentenced to the gas chamber? Say to that defendant, since you talked to a reporter, I'm going to give you 5 days in jail for contempt. I'm speaking not with reference to this case, but with reference to gag orders generally. So when the story of this defendant was printed in the Los Angeles Times, big deal. Who was surprised? We all anticipate that at some point a defendant in a major case is going to talk to reporters, and there's never been anybody yet figure out a way to prevent it, and I'm not even sure it's, even if you think it's a good idea to prevent it, there's no way to do it.
Mr. Younger, what was the policy and what is the policy of the District Attorney's Office regarding the death penalty in the Tate LaBianca trial?
Well, the district attorney, when I was district attorney, was seeking the death penalty and apparently still are.
Mr. Younger, do you think that Miss Atkins' story in the Times, as you know it, based on what you understand, is more closer to the truth than what happened in the Tate LaBianca case than what she told the grand jury?
I haven't read her story in the Times. I don't know what she says there.
Nowhere on the manuscript or the accounts what you've heard or...
Right. I have not read it, and so I couldn't answer your question.
Mr. Younger,
certain lawyers as qualified, and lawyers that are not qualified should not be permitted to try a capital case. That's one of the provisions we're going to include in our package.
Now, at the beginning of this trial, you offered the Supreme Court evidence of Mr. Koenarik's, quote, incompetence, end quote, as I recall. After seeing his performance this morning, what is your attitude, or has it changed from that time?
It's with great reluctance. I don't think I can properly answer that.
Mr. Younger, were you personally responsible for both decisions regarding Susan Atkins that came out of the district attorney's office?
I approve both. In that sense, I was responsible for both of them. Yes, sir.
Could you tell us what the arrangement was, Mr. Younger?
I'll give you a memorandum.
Would you do that, please?
Yes, sir. Thank you. It very clearly spells it out, and this is in evidence. You can all have a copy of this.
On the question of competence of counsel...
Well, wait a minute. Let him answer the question.
Well, I don't want to read the memorandum, but I'll just give it to you.
Could you just verbally tell us what the arrangement was?
The arrangement on December 4th was that I think it was proper. It has nothing to do with my being on the witness stand. Our actions early in the trial, our actions to try to force a determination by the appellate courts prior to trial that a certain lawyer was or wasn't competent was, in our opinion, in the public interest. We hate to be put in the position on appeal. We have been many times where a defendant who's convicted will get a new lawyer, and the new lawyer will come into court and say that this defendant was not adequately represented at the original trial, therefore he didn't get a fair trial. And no one questions but that's going to happen in this case, and naturally we felt it was in the public interest to try to avoid it. We could not avoid it.
If that were to occur and the competence of
Sequestering of the jury came after two prosecuting attorneys said they were told this morning by Charles Manson there would be murder and bloodshed if he received the death penalty. The remark allegedly came in a casual conversation between Manson and the attorneys. Defense attorney Paul Fitzgerald was livid over the whole affair, while prosecutor Vincent Bugliosi was vague.
Because of that comment, Joseph Bush, the district attorney of Los Angeles County, and myself asked Judge Older, and we did have the concurrence of all four defense attorneys, to sequester the jury after today's session. Judge Older granted that motion, and the jury will be sequestered.
You care to comment on those remarks?
You're going to take the taxpayers' money to sequester this jury because the prosecution deliberately disseminated for public information a statement allegedly made ex parte to the district attorney. Bear in mind that you only have one side of the story, that Mr. Manson can't answer these allegations, that Mr. Manson's being held incommunicado. Minimal standards of fairness would require that you get both sides of the story. Furthermore, this statement allegedly was made outside the presence of Mr. Manson's attorney. Mr. Koenarik didn't know anything about it. No defense attorney knew anything about this until 2 o'clock in the afternoon. Yet the material was disseminated to the media at 10 o'clock in the morning by virtue of a release by the district attorney's office. That's why you had Mr. Bush here. That's why you had Gordon Jacobson from the district attorney's office and John Howard here. Because they know it's reversible error. They know that if this jury got exposed to that kind of virulent, inflammatory information, they'd have a very difficult time being fair in their determination of penalty.
Upon sequestering the jury, Judge Older told the members he had hoped the trial, the penalty phase of the trial, would have ended today. But it didn't, and the judge said this latest hotel stay would probably be just overnight. However, other observers say it may be much longer than that. Phil Nye, Channel 5 News reporting. Bugliosi, what about the comment this morning made by Charles Manson?
I can't say too much about it. I'm not going to give you the content of the comment. He did make a comment early this morning. Somehow it was released to the press, and now it's gone almost all around the world and back. Trial.
Do you have more to say tomorrow to the jury?
Will I have more to say tomorrow? You mean in my argument? Yes. I should finish tomorrow at about 11 o'clock, 11:30.
Thank you. Rolling. The remark.
Well, I certainly am questioning the truthfulness of the remark. And in addition, assuming the truthfulness of the remark, I'm talking about the ethics of disseminating it in violation of a court order.
All right, go ahead. You rolling? Mr. Kanarick, one of the co-counsels on this case seems to indicate that the prosecution has disseminated this remark allegedly made by Charles Manson for benefit of the prosecution. What do you know about it?
Regrettably, I just cannot comment or make any statement in connection with your question or that subject matter.
Do you feel that the prosecution did release this statement supposedly made with no defense counsel near so they could use it to their own benefit?
Well, because of the publicity order of Judge Keene and Judge Older, and because of other matters such as the attorney-client privilege, such as the fact that there is law covering this subject matter, I don't feel that I can make any statement.
Is Mr. Fitzgerald within his rights in making the comments he made?
Well, I can't make any comment concerning...
You concur with what he said?
Well, I just cannot make any comment. I just, I respect you're trying to do a job and all of that, but I also have an obligation, and the only thing I can say is no comment.
No way it means progress about.
Upon sequestering the jury for the night, Judge Older said he had hoped today would bring an end to the penalty phase of the trial. It didn't. The judge told the jury members Take it again. Upon sequestering the jury for the night, Judge Older said he had hoped the penalty phase of the trial, would have ended today. It didn't. So the jurors went to the hotel. The judge said he thought this latest hotel stay would just be an overnight affair. Most other observers, however, feel the jurors may be at the hotel for some time to come, perhaps up to a week, before the penalty phase does end. Phil Nye, Channel 5 News reporting.
I think the jury, if they're able to arrive at a verdict, will arrive at it very quickly. I would guess that the jury would have a verdict within 2 days. That is, if they're going to agree. Now, the death penalty, death versus life, is an emotional decision. It's a very personal, individual decision. These jurors have been thinking about it for at least 8 weeks, and perhaps even as long as 9 months. So I think that they're relatively secure in their position.
Mr. Bugliosi, it's been more than 10 months. Do you breathe kind of a sigh of relief? Are you satisfied with what you have done?
Well, it's been a very long, complex, vigorously contested trial on both sides.
representing the prosecution, which in turn represents the people of the state of California. I am satisfied that the prosecution did all we could to convince the jury of the guilt of these defendants and the fact that in view of the brutality of these murders, the defendant should receive the death penalty. That ultimate decision, of course, is now in the hands of the jury, 12 people chosen from this community, and I'm satisfied that whatever verdict they reach is going to be a fair verdict and a proper verdict under all of the circumstances.
Is the appeal of the defense attorneys to the jury in this penalty phase?
No, I'm not going to pass judgment on their arguments, other than to say that most of their arguments were common arguments made by defense attorneys in a capital case. They appealed for mercy, which is expected on their part.
Thank you very much.
Thank you.
Mr. Fitzgerald, you've been involved from the very start. How do you feel now that your end of it is over?
Well, it's a tremendous emotional relief. We're all physically and emotionally weary. We've been actively in trial for 9 months, plus we were engaged in rather rigorous pretrial motions for 3 months before that. It's been a long trial, and
Are you
damn glad it's
satisfied
over.
with what has happened? The way you have conducted your part of the defense?
Yes, I think that if I had to do the entire thing over again, given the situation and given the circumstances, I wouldn't have changed a thing.
In your final argument today in the penalty phase, you were interrupted. Were you censored by the court for your material?
Well, there's a thin line between what is proper argument and what is considered to be legally improper. Counsel need not refer in their argument to just those things that have been mentioned in evidence, but can draw illustrations from everyday life, from things and facts that are part of the public domain, and things that are common knowledge. I was stopped from arguing to the jury that the court exercises a pro forma function, and that anybody, in terms of immunity, and that whenever the district attorney petitions for immunity, they get it. Now, I know as an attorney that happens to be an absolutely true statement. Never in my experience, nor in the experience of any other attorney, has there ever been a situation where the court refused immunity. But in the unlikely event that a court at some future time would not allow somebody immunity, the prosecution simply need not prosecute them. And that was one of the points at which I was interrupted. Another point was dealing with the prerogative of the prosecution to put on psychiatric evidence. And another point was when I was attempting to describe the ritual on execution day, and fortunately I won that argument, and I was allowed to tell the jury, or allowed to ask the jury to imagine the execution day for Patricia Krenwinkel, Susan Adkins, and Leslie Van Houten.
Would you care to hazard a guess as to how long the jury will take in this penalty phase of their determination?
Of the same mind, I think they'll reach a verdict rapidly.
Long.
Oh, we've been working on it for about 4 years, about 12 of us.
Hold that, what does it look like? Does everybody contributed to it?
Yeah, all the girls in jail.
The Tate LaBianca jury spent their first full day of deliberation today in the penalty phase of the trial of Charles Manson and 3 of his female followers. With a total of 27 possible verdicts, the experts do not expect the jury to return to the courtroom in any record time. The attorneys on both sides admitted yesterday, after their final arguments and Judge Older's instructions to the jury, that they are emotionally and physically drained after more than 9 months of the trial and are happy to have time to rest. The attorneys are on a 45-minute callback in the event of a decision by the jury. About the future of the Manson family, I talked to 4 of the girls at their corner vigil outside the Hall of Justice: Brenda, Sandy, Cappy, and Kitty. Sandy, you've probably been here as long as anybody keeping this vigil, and it now looks that it will come to an end, that they will move the girls and Charlie. What do you girls intend to do?
We'll be here until he gets out. After this trial, there'll be another trial, so they won't move them for quite some time. But we'll be here until he's out, and he is coming out.
What about the girls? What do you feel about the girls?
I love them, and I'm with them wherever they go, in spirit, and they'll also be coming out. Sadie won't be transferred for quite some time because there's that Hinman Shea trial coming up. But
But if they do move them to some other place, will you follow?
Charlie will be coming out soon, and they won't be moving him for some time.
And all of us here on the corner.
How long have you been working on it?
About 4 years. It's for Charlie.
And he will wear it, huh?
Yeah, he'll wear it.
Very confident, right?
Sure, well, we know.
Is that part of the part of your ideal that you do know? You're positive.
Oh, we're completely positive. The jails are coming open, no question. All the jails and the penitentiaries are going to be open very soon.
I notice that you all sit in the same attitude with your hands the same way. Is it significant? What does it mean?
We're on our knees. We're giving up.
You're giving up?
Yeah.
Not on Charlie and the girls, though.
No, we're with them. In other words, we give up the system. We're down. We give it to whoever wants to take it. We vex ourselves out of the system, and we give it all up.
I understand that there are some people that are trying to rescue you from time to time.
Oh, the Jesus people, yeah. Yeah, the Jesus people have, in other words, people see that this is the end, that a revolution's coming, or a lot of big changes are coming. And the Jesus people are slipping into the minds of all the people that are confused and don't know where to go.
Do you feel that the end is in sight and a change is coming also?
Big changes are coming real soon.
You're kind of thinking the same way they are then, aren't you?
Well, everyone you meet talks about it.
Even the little old ladies who sit on the corner who have had their welfare checks taken away, and the little old man and all those people, they all come on this corner every day of the week, yelling about revolution and that about the people who are in power better give it up. Nixon better give it up, because if he doesn't, the whole thing's going to be destroyed.
Do you feel that you see a limited segment of life as you sit here, that most of the people that come by here are in trouble?
No, you know what, we see, on this corner we mostly see the people who've been down, for all their lives, because these are the people who are going to court, the black people, the Chicanos, these are the people who spend most of their lives in these courts with their sons going to, jail, and their daughters going to jail. And we see every kind of way of life there is.
Do you think that you might write a book, chronicle your experience here on the corner?
We have a book already.
Do you?
Oh yeah, it's Charlie's writings, our writings from when we all got together. But people have created an image of us all, and the book kind of is contrary to that image, and so they want to perpetuate the lie they've created about us. So really nobody really wants the book.
Oh, I think you'll find somebody that wants it. A lot of people. Thank you so much, girls. Nice to talk to you.
Okay.
Oh, did somebody put that on? Just the first name?
That's fine.
Yeah.
Like a flare pen.
Yeah, it's a thick and some watercolor pens.
But the stuff is inside the pen.
Yeah.
You don't give it any.
Well, I figured they were just flamboyant about the whole thing there. They didn't seem like they cared one bit about anything. They were just ridiculing the judge and the court and our laws, and I didn't think it was proper for them to act that way.
You think that was an influence in reaching your decision?
No, not necessarily, no. Our influence was mainly from the witness stand. You mean financially?
To make a deal for an exclusive interview with...
Well, I'm not making no deal with anybody.
You know of this, don't you?
I've heard of it, yeah, I have heard of it.
Well, we have substantiated fact that he was talking to an attorney before the trial was over about making this deal. This could jeopardize not only the juror's verdict, but perhaps the whole trial. Do you have anything to say?
It's not true. I mean, as far your personal...
I have no knowledge of that. I actually haven't got no knowledge on that.
Of which?
Of the facts that you say that he's not a thing that I know of. I haven't heard him make any comments at all.
Did he ask the jury or suggest to the jury that there was some money to be made if you all stayed together and offered your story together?
That was after the penalty phase?
Did he ever make that statement?
Yes.
When?
When did he make that statement?
Oh, that was made after the penalty phase was read off. After we handed the verdict to the judge. After it was all over with.
And then what did he say?
Well, he mentioned something about if we all stuck together there, that it could be making a package deal to capitalize on it.
What was your reaction to that?
My reaction to that there? I didn't think it was right.
Why?
Huh? Why? I believe that I'm rewarded my way there by doing God's will, that I was there. I mean, it was God's will that I was performing a service, and it was my civic duty to society, and that I brought, and that justice was served.
Has Mr. Shealy continued in his efforts to bring you all together?
No, I haven't. I haven't talked to any jurors, and I haven't spoken to anybody but you folks right now. This is the first time I've spoken to anybody at all. I don't get the.
In other words, you said you found the idea of this deal that's been talked about objectionable. My question is, why did you find it objectionable to give anyone your version of what went on? The trial itself is over. You're free to do this. You have some kind of legal or moral responsibility?
No. I look at it this way there, that my purpose has been served. I mean, I served my purpose to society, and that's what it was my civic duty there. And I figured this way, that it's all over with now, and I want to forget it.
Mr. Tubick, are you under any restraint about making a deal now for yourself or for putting together a package of the jurors to sell?
I'm not making no deal at all there. I'm rewarded myself and that I've served society and done my civic duty there and saw that justice was brought about.
Do you have any? I'm not making
no deals with anybody as far as me
money or
capitalizing or anything like that there.
Do you have any objection to doing that if somebody approached you properly?
I don't see no sense in it. I'm serving God. I mean, I'm serving society, and that's the way I look at it. I'm not looking for any finances or reward. My reward is that I already done my duty.
Mr. Tubick, do you feel that if Mr. Shealy...
No, we had no decision, and we had no hardships about reaching a decision. There were discussions, there were problems that came up there, but that...
What were the nature of those problems?
Well, we had a lot of the facts kept away from us, and we just had to go by that what was coming off of the witness stand.
By having the facts taken away from you, I mean you weren't allowed to review the transcript or things you didn't hear that...
We didn't know anything about the transcripts. I'm speaking for myself. I never knew there was even a transcript about for the grand jury.
Aside from your own memory then during the trial and the notes that the other jurors took, do you feel any threat at all, or have you been threatened?
No.
Have you had any phone calls, notes, or anything else?
No, sir.
Any contact from the Manson family, or members of the Manson family, or persons who might be associated with Manson?
No, sir.
Mr. Tubick, one of the jurors has gone on record on television as saying that during...
Well, I don't know in which way they mean that. We've had our associations and we've had our inside jokes and we've played around. I mean, we had to in order to amuse ourselves there, but if anybody was having any hanky-pankies or anything like that, I really don't know.
What was it all over again? Would you do it?
Would I do it all over again? It was God's will, yes, I would.
Would you have no regrets spending almost a year of your life away from your family, your friends? You feel that being deprived of this was worth your civic duty?
It was, yeah, and I'd do it all over again if I had to. I really mean it.
Do you feel that it was proper to have the jurors sequestered for this long a time? Do you think the sequestration served a purpose?
Yes, it has. And I have no objection to being sequestered all over again if I had to
Do
be.
you think it's necessary?
I think it's necessary, yes.
Why?
That way, it wouldn't change any individual's outlook on giving a proper verdict.
You think they could have been swayed by publicity?
I think so, yes. I believe that's true of any case.
Did anything occur when you were released? You just held it up.
Well, it held it up, and then I think Mr. Keith done a good job. I mean, it helped Van Houten on that case.
Did the jury have any idea that Mr. Hughes might have fallen victim of foul play?
No, we thought, well, maybe he just took off and was just taking a vacation, maybe delaying the case. Of course, it kind of upset us there, because we didn't see why anybody should be taking a vacation when we were being sequestered.
Did you at any time?
No, it hasn't. No,
Did
it
you at
didn't.
any time think that he might be dead?
There was speculation on it, yes.
Mr. Tubick, how did the antics of the...
It didn't help him any.
How did you
Well, it was amazing.
annoy you, or see in your mind, well, did he have any effect on you?
On television said there was promiscuity. He was asked if he meant that word, or did he mean just being relaxed and cool. He said no.
Death or life. Had you had the choice of a lesser sentence, maybe even life with the possibility of, without the possibility of parole, would that have made it easier for the jury to reach it?
How do you think that he did have? What was his involvement in the murder, do you think? After the
That's what you told me. He was the leader.
Well, he was the leader. I mean, if he wasn't there, nobody, I can't see no possible way of any of them getting an appeal.
Do you think that?
Well, justice was done.
In other words, they retribution for what they did?
Yes.
That will be the only point of their execution.
Well, that's the only thing. What else could I go on?
Billy, after observing Charles Manson very closely for more than 9 months, what do you personally think of him?
Well, he's, from an artistic standpoint, he's a man of 1,000 faces. He said that on the witness stand, and it's really true. He has more expressions on his face than possibly anyone I've ever, really observed before. He can be, very angry, and then at the same time, a little later, maybe express a very gentle quality. It's amazing, really, to watch that. And just from a personal standpoint, he, really has exhibited these qualities, which are very unusual, I think.
Which of these characteristics did you observe most of the time?
Well, unfortunately, I think there were only a few exceptions when he became violent, and the rest of the time he seemed to be, in a very carefree mood. Not really, well, more or less just as like he was enjoying everything that was going on, and that was kind of the impression that I got, and also from the three girls as well.
You think they got a fair trial?
Yes, I do. I certainly do. I think the judge and the jury should be really commended for, what sitting through 9 months, first of all, and then I think if also the jury for taking off from their jobs and listening to the testimony. I think they did. I think they evaluated it in the same way that I would have evaluated it, and I think they came out with a proper decision.
Your shot, just a two-shot. Tell me anything. How did your husband like his job?
Oh, he enjoys it very much. He works with General Electric Computers, and he's been working with them now about 2 years, and he really enjoys it.
Well, the only thing I know about computers is the fact that they have some knobs and buttons on them and that sort of thing. But you must be very opposite since you pursue art and he pursues computers.
No.
I will let a couple of frames go by the camera. And even the defendants talked about it, but what do you think motivated these four people to do the things they've been convicted of doing?
Well, that's a difficult question. I don't know if anyone really knows.
What's behind it?
I'd say possibly drugs could be, could be a major source of the problem. I think Manson being a habitual criminal had something to do with it. And I don't know, it's just very difficult to say. I don't know if anyone can really, pin it down as to what caused it.
They seem to enjoy restating their position that they felt no remorse over the killings. Is that really true, do you think?
Yes, I really think that's true. When I observed them on the witness stand, they seemed to be, again, very carefree, very, they seemed to feel like they were right in what they did, but there was nothing wrong with doing what they did, so I don't know, it's really kind of a sad situation, They really didn't feel any remorse at all that I could
Screamed at Judge Older that he wasn't able to put on his own defense. Do you think Irving Kinerick did defend Charles Manson in the trial?
Well, yes, in a way. I think Kinerick may have done what Charles Manson wanted him to do. I'm not sure that Charles Manson really wanted a defense in the first part of the trial.
Or was it an adequate defense?
I'm not a lawyer, so I'm not going to say on that. I really wouldn't say on that question.
What was the most dramatic moment in the trial to you?
I think the most dramatic moment was when Charles Manson leaped over the counsel table and made an attack upon the judge, tried to make an attack upon the judge. And that was, I think, by far the most dramatic moment, because I don't think anybody expected him to really do that.
If you can think back to that moment, what went through your mind at the time when you saw it all happening? Could you believe it?
Well, first of all, I had difficulty seeing it because the attorneys all jumped up, and they blocked the artist's view. And so we were a little uncertain as to what was going on at first, and then we could see them struggling on the floor, and then the two bailiffs put him under control, got him under control. And I was very surprised and kind of wondering, what's going to happen next.
You sat in the courtroom with some of the top journalists from all over the world covering the trial. What's your opinion of them?
I have a very high opinion of them.
What did you learn about news reporters as you observed them operate, as you observed them interviewing attorneys in the hallways and so on?
A very active group, and they seem to be very thorough in their job. And I thought they did from what I observed, I think most of them did a very good job of reporting on the trial. And
the publicity did not influence the jury, in your opinion, from your standpoint, what you observed?
Not at all. Not at all. I don't think it influenced the jury at all.
You saw the thing yourself each day as it unfolded, and then you got home at night, you heard the news reports, you read the papers. Was it generally treated very fairly or not?
Yes, I think so. I really do. I think everything that I observed during the trial, each day was almost invariably, very accurately reported upon. And I can think of no instance where something to the contrary, was said on the news that when it actually did not happen in the courtroom. I know of no instance.
After observing him at very close range for more than 9 months now, what do you think, personally, of Charles Manson? The attorneys have talked about this and the defendants themselves, but I wonder what you think motivated these people to commit the crimes that they're convicted of committing. That isn't what I said the first time around. What do you think motivated these people to commit these crimes? Do you think they got a fair trial? What was the most dramatic moment of the entire trial? What do you think was the most dramatic moment in the trial? That's enough.
Obviously, there is no statute of limitations for murder, so simply because they don't prosecute Manson at this time doesn't mean they can't prosecute him at some time in the future. They can prosecute him. I think you should also be informed that the prosecution knew of these other offenses. They knew of the so-called Shorty O'Shea case, and they knew of the Hinman case in advance of the prosecutions in Tate LaBianca. It's Kinneric's position that the prosecution was required to join all these offenses and try them at one time and place. To drag it out indefinitely is in a sense a cruel and unusual punishment.
Mr. Fitzgerald, what are you attempting to accomplish by your visit to the county?
Well, Mr. Kinnerick and I approached Kenneth Hahn, a member of the Board of Supervisors, and we asked his assistance in perhaps instituting a taxpayer's suit to enjoin the District Attorney of Los Angeles from proceeding with any further prosecution of Charles Manson. We pointed out to Hahn that Manson has been convicted and sentenced on 7 separate and distinct murder offenses. He's been sentenced to death 7 times, and that it's certainly not in anybody's best interest to continue to prosecute him in order that they can get 2 more death sentences or 3 more death sentences. We're concerned, it's almost like Charles Dickinson's Bleak House. There just isn't going to be an end to this litigation. We approached Hahn because Hahn considers himself to be the guardian of the taxpayers' purse strings, and we estimate that the case will cost these additional prosecutions to get this unwarranted sort of death penalty against Manson will cost the taxpayers an additional $2 million. And we just don't think it's in anybody's best interest.
In other words, you're looking at the economy as far as the county's taxpayers are concerned?
Well, quite frankly, our interests are somewhat different, but we know that's the way to approach Hahn, and we know that, of course, while we know, of course, that he has influence in molding public opinion, and we know from other sources that the taxpayers of this county are very, very disturbed about the amount of money it's cost to prosecute Manson and the other defendants already, and we thought we could coattail them.
What will become of that case then if no one is ever tried for it?
Well,
legally, what is happening?
Well, Manson and Adkins don't want to be present. They don't have any interest in dragging out this case. As a matter of fact, they'd be very happy if they just were allowed to go on to prison, go on to their respective death rows, and be informed of the verdict by postcard. It's really the prosecution that wants to continue to prosecute these defendants, ostensibly for some sort of insurance in the unlikely event the case, the Tate LaBianca case, is reversed on appeal.
What happens when the case is stopped? Are you attempting to quash the original murder charge against Hinman and O'Shea, or for Hinman and O'Shea?
Well, we approached Hahn.
Where does it start?
We approached Hahn, and we asked Hahn to perhaps consider the advisability of the Board of Supervisors on behalf of the taxpayers of the county instituting a lawsuit against the prosecution to restrain and prohibit them from any further prosecution, on the ground that it's an idle act, it's unnecessary.
Does it take a lawsuit, or can't somebody just declare it?
Well, as Hahn pointed out to us, Hahn, although he's not an attorney, Hahn pointed out that in his opinion, based on legal advice he'd received from the county council, it's rather questionable whether a lawsuit would lie. But Hahn did express an enormous amount of interest. First of all, he was unaware that they were going to continue to prosecute Manson. He was unaware of that fact initially. And secondly, he said although he could not, or he didn't feel he could institute a lawsuit, that he might go to the public with it. He might point out to the taxpayers of the county that they're going to be required to spend an additional $2 million or $1.5 million dollars to prosecute somebody against whom you already have 8 death verdicts.
Are there any other persons involved who might escape trial for those 2 crimes if it is dropped against Manson and Atkins?
Well, I don't think so. Of course, there are 2 other defendants. There's Bruce Davis and there's Steve Grogan. Now, we did not suggest to Kenneth Hahn that they shouldn't be prosecuted, and most observers feel that if Manson and Atkins are removed from the case could be tried with relative dispatch at a relatively small cost to the taxpayers. But with the presence of Manson and Manson's attorney Kanarek and the presence of Susan Atkins, the proceedings are likely to take a substantial amount of time, and they're likely to be an enormous amount of attendant publicity, etc. So all we're suggesting is that Manson and Atkins not be prosecuted, not the other 2. They're certainly entitled to be convicted or vindicated as the case may be.
What chance do you think you have of having this accepted?
Well, it's difficult to say. Our legal position appears to be somewhat tenuous in terms of actually instituting a lawsuit to restrain the district attorney of Los Angeles County. On the other hand, as Kenneth Hahn pointed out to us, the influence of public opinion is tremendous. And there is, I know from my own personal experience, everywhere I go, the big topic is the amount of money it's costing the taxpayers. And so I think the pressure of public opinion may well influence the prosecution in the overall handling of the case.
Paul, thank you very much.
Bet, Dick.
Appreciate your time. Very kind of you.
Yeah, I might say.
Mr. Fitzgerald, would this amount to dropping the charges against Manson and Atkins and anybody else involved in the trial? Are there others who would be on trial who would escape prosecution if this was dropped? With what success do you think you'll meet?
You know, this and that and the other, and everybody looks at it and reads it, and then they go on doing what they're doing, saying, oh no. It's all a question of whether or not they're going to let us go in peace, or whether the madness will have to be strung from one end of the city to the other.
What do you mean by madness, Brenda?
In other words, the people who've been judging, these people who've been judging, they're going to be judged as they've judged. They're using the courtrooms to murder people, innocent people. And this whole trial has just been the truth on trial. They don't have anybody on trial other than their children and the truth. And they can tag us with names, you know, and they can tag him with the name Charles Manson, but he's the truth.
What about your future? Are you going to stay here and you'll get older and older and older?
We get
Still
younger
be
and
here in the
younger and
corner?
younger.
So, what do you think of your future? What are you going to do in the future? What are you going to
You
do
know what?
tomorrow?
We don't live in your time. We live in no time. There's no future and there's no past. It's just now, all the time. This city is going to be burning very soon. This city's coming down. The city is falling. Babylon is going to fall. Were you here this morning when they took him?
No, that was real early. Were you girls up?
Somebody was here taking pictures. Somebody was here taking pictures about an hour before dawn.
How do you feel about it, knowing that he's not in there now? Did you have any idea of following him up north for the time that he'll be there?
No. In other words, we're in our thought. We're all in one thought, and they can't separate us. There's no way. In other words, we're together.
Well, you're Brenda and Cappy and Kitty sitting here. Sandy's missing. Mary's missing.
Oh, they're moving the truck.
Oh, are they? Where's the vest? I understand that you put some of your hair on the vest. Is that true?
Yeah, all of us and all the girls in jail. And it's all around the collar, just hanging down over the vest.
How does it look?
Oh, it's beautiful.
Really?
It's really beautiful, yeah.
When do you suppose he's going to get a chance to wear it?
When he gets out.
Still have a lot of confidence.
Sure.
Kitty, you're sitting here not working on anything at this moment. What kind of thoughts are running through your mind?
No thoughts.
No?
No thoughts.
You miss the fact that Charlie's not up in this building?
He'll be back. He has another trial.
Hey, where did they go?
What?
Well, whatever they do to him, they have to do to us.
I don't know. Why would they have to do anything to you? You guys haven't done anything.
It's like when Judge Older sentenced them all to go to the gas chamber, he sentenced the 3 girls to death in the gas chamber. He sentenced Charlie to death in San Quentin. He didn't say the gas chamber. In other words, for Charlie to come back down here and go on trial, the whole other trial will come out in the open. All the witnesses who've been coerced, all the shady deals, all this will come out in the open. So the last thing they really want is for another trial to go on, because it's going to show. The only thing that we're concerned about at all is our children. That there's something left for our children.
And are you making a place for your children here? Is this what?
Here?
Yeah, what you're doing now.
In other words, we are speaking to all the people of my life, for my children, to see that there's something left for them.
Is that the reason
I
you
mean, look
think?
in the newspaper. The Earth, all these articles about the Earth. You know, is it going to last? Is it going to... Well, no, you know, it's getting pretty heavy, you know. They're ready to put their finger on that button and blow the whole thing up. And, like, we see that there's something left to save for the children. If it's just a sunset, you know. It's like, the way it's going now, everybody's going insane.
Cappy, what are you writing? You writing a letter to someone, or just putting your thoughts down on paper?
Yeah, I'm writing to my brother in the penitentiary, one of many brothers we have in the penitentiary.
that we're in touch with.
What do you tell them? Just about what's going on outside?
You know, what I see out here.
Are you at all optimistic?
This morning, here we are.
Yeah, as the vehicle comes out, it'll be on this side. Right in the back.
Sheriff's deputies searched a rundown chicken ranch outside of Lancaster Lake today. They were investigating suspicious diggings around the ranch where 5 missing children of a Manson family member were found yesterday. The children were discovered hiding in a 5 by 3 foot covered dirt hole in a chicken coop at the back of the ranch. They were unharmed. The ranch has been identified as a hangout for members of the Manson family. Sergeant Charles Gunther, who's been working on the Manson case from the very beginning, was at the scene today.
Early this morning, we received information that there was possibly a body or bodies up here, that there were mounds of dirt that indicated there were grave sites or simulating burial sites. But we ordered in the posse, or asked for the posse and the assistance of our Emergency Services Bureau, and they've checked the area, and all of the sites that we found don't indicate anything like that.
Were there similar diggings or holes at other Manson family locations?
Yes, in Goler Wash there was burial sites like this that we actually thought at the time were bodies, and upon digging them up they were nothing. Very similar to what we have here.
2 juveniles were arrested at the site yesterday on narcotics possession charges, and a 14-year-old runaway girl was found at the ranch and placed with juvenile authorities. From Lancaster, Stan Chambers, Channel 5 Action News, reporting.
Yeah, fine.
Sergeant, what have you found here?
Well, we came up here because of the children that were found yesterday being part of the Manson family, and me knowing, or because I've known them in the past years. We found 4 children in a small hole here covered over with a piece of plywood, and then 1 baby in a larger hole. We did have a runaway located, a 14-year-old runaway that was located inside the house.
Just how does this connect with the Manson family, Sergeant?
The 4 children that were found in the hole are the children of one of the Dennis Rice, who, although he wasn't attached to the family in the first year that I knew the family, he became associated with the girls later on, and while they were on the corner.
Sergeant, you've been to many of the family locations. How does this compare with some of the others?
I'd say this is a typical family hangout with the dirt, the way the children are living, and I see no difference between here and Gold or Wash or Spawn Ranch.
You say the children were back there hidden. Do you think that the children were hiding from the officers when they came here, or do you think they were placed back there?
Well, I don't know whether they were placed, but ordinarily that's what they were taught to do, to hide from the police. They were taught to run to places like that. It would be possible that the older ones could have run back there, but the smaller ones, I would suggest that they were placed there.
Has the parents of the little baby been identified?
No, we have one young child that hasn't been identified yet, and we're in the process of trying to make that identification now.
The search party today and the men on horseback, just what are they looking for? Or is that typical also?
Absolutely. When we were in Gold or Wash, we recovered a great number of dune buggies that they had moved in under practically inaccessible terrain. This is a general Manson-type residence, if you want to call it that.
What is the status now of Rice?
I talked with an officer this morning, and he tells me that the Dennis Rice was released about 3 weeks ago, although I don't have any personal knowledge of that. He had been held on a grand theft charge. I really don't know what the exact status is.
Now, have the 4 children been returned to the mother?
Not as yet. In fact, we're trying to reach the mother now. We're in the process of trying to find her.
Isn't that too bad? Down in the front, please! You gotta get a real good shot of it, yeah.
I know him. Well, you did it again, didn't you, punk?
Down in the front, please. Down in the front, please.
Okay,
okay.
You want to hold it up here? We got to get these prisoners through.
Yes, sir. Move over. Let me go over here.
Sorry about that.
Down, Sam.
Yeah.
Come on, Ben.
Got it?
Huh?
No communication with anybody in custody, ma'am.
Well, it's the policy of the district attorney's office that attorneys should say what they have to say in court. I have done so. I have no further comment at this time.
Prosecutor, you did bring up one interesting point. Why did they want to use the weapons?
I cannot. You did.
Well, the reasons for the second trial have already been stated, I think, by Mr. Bush. There are several reasons for the second trial. In the first place, there's the question of an appeal in the Tate LaBianca case. In the second place, the charges in the second trial are murder charges, perhaps the most serious crime that can be committed by anyone, and not charges lightly to be dismissed. In the third case, I think the involvement of Mr. Manson and the other persons who have been convicted of murder indicated the sort of the type of thing that should be prosecuted to the fullest extent.
Will you go for the death penalty?
There will be a penalty phase in which the jury will decide which penalty to impose, life imprisonment or death, for the crimes of which Mr. Manson's been convicted.
What about this outburst that he made right after the verdict? Did you hear what he said?
I heard him say something. I don't remember what he said.
Tony, what is your reaction to the amount of time that they deliberated over the 9 days in relation to the small amount of deliberation time in a Grogan trial?
Well, I think that the length of deliberation in this case shows the difficulty in prosecuting a murder case in which the body of the deceased has not been recovered or produced. I also think that it shows the fact that the jury in this case was not influenced by pretrial publicity about Mr. Manson, that they made a conscientious effort and did make a conscientious effort to return a verdict based on the evidence in this case.
How quickly after the second part of the trial is finished will he be taken up to San Quentin?
I don't know. I don't know.
With Manson already under a death sentence, why was this second trial necessary?
That would depend on the evidence offered by the defense. I really don't know. It should last perhaps a week.
Why was the judge so deliberate in asking whether the jury had seen or read or heard about the Manson case?
He was referring to the verdict, death penalty verdict returned in the Grogan case over the weekend while the jurors were deliberating. However, he established that all television and radio and newspapers were removed from the jurors prior to the time the verdict was announced, so that the jurors could not have heard anything about the verdict in the Grogan case.
Thank you.
Thank you. You're welcome.
As to your interpretation of what happens in the courtroom, I can only say that the attorney-client relationship is not, it's a viable type of relationship. People do not agree. And when a man has just been found guilty of supposedly 3 counts of first-degree murder, it's I would think automatic that he would become unhappy with the person that's representing him.
Well, what did he say in the courtroom after
pardon?
the verdicts were read? What did he say in there to the judge?
Well, I say, by the way, I say purportedly found guilty. We got to remember that this deliberation, I think, is some 10 or 11 days in time between the time that the jury went out and today's alleged verdict or verdicts.
Why do you call them alleged?
Pardon?
Why do you call them alleged, Mr. Canary?
Well, because, thank God, we have, in this country, we have appellate courts, we have certain guarantees, hopefully, that will protect defendants from the political circus atmosphere that the district attorney and the present attorney general of California have deliberately, and the chief of police of Los Angeles have deliberately put upon Mr. Manson. It's interesting to note that the scandal, for instance, that's developing in the Los Angeles Police Department may well involve people who have had a lot to do with the prosecution of Charles Manson. The Tate LaBianca case was prosecuted practically completely by the Los Angeles Police Department. None of us, I don't care whether we're lawyers, judges, policemen, none of us are incapable of having human frailties. And when you impose upon a trial the publicity that has occurred here, are you sure that the man is getting a fair trial? I mean, when you look as to what happened.
Have you talked with Manson since? Have you talked with him privately since the verdicts?
No, I haven't talked with him since the verdicts have come in.
There was an outburst in court.
I might say this, that every one of the jurors in this case, it was impossible to get a jury where the jurors did not know the results of the Tate LaBianca case. Each one of us consider whether we feel that we would like to go to trial where, in a case where everyone on the jury knew that we were convicted allegedly of 7 counts of murder and had received 7 death sentences.
Why did you have the verdicts reread?
Well, that's a point. That's a technical point of law for the record and for appellate matters.
Well, Mr. Canary.
Well, you were in the courtroom, sir. I did not memorize. I don't try to memorize what happens in a courtroom. I try to look at the record and see what happened.
Did you read the record of what he said?
No, it hasn't been typed up yet, so it's not possible to have read it. So I really don't know what words Mr. Manson said. But there are times in a person's life.
Cut it.
When well, I can't discuss that because the attorney-client privilege that we're going to assume that such the case. That any one of us were in the kind of custody